Somebody needs to mute their computer.
If all speakers and mics are muted, there shouldn't be an echo. I'll just make sure that your mics and speakers are muted as well.
And Brad, the chairman is also a host, correct?
Yes, I am a co-host.
All right, thank you.
All right. Let's begin. Good morning. Today is February 10th, 2021. It is 9:05 a.m. As the chair of the Criminal Justice and Public Safety Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing with potential for executive sessions to be held throughout. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting complies with House rules and RSA 91-A. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. I want to introduce the staff that are on the meeting assisting us. Brad Friedland, the committee researcher. Please note that all votes that are taken during this meeting shall be done by roll call vote. Let's start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there is anyone in the room with you during this meeting, which is required under the right to know law. Clerk will now take the roll.
Vice Chairman Welch,
Yeah.
Representative Burt,
Yes, and Gary Hopper's here with me.
Representative Hopper,
Here.
Representative Green,
Here.
Representative Wallace,
Here.
Representative Testerman,
Here.
Representative True,
Here.
Representative Pratt,
Here.
Representative Marston.
Present.
The clerk is present. Representative Harriet Gathright, Representative Pantelakis,
She's unmuted herself.
I am here and alone.
Representative O'Hearn,
Present, home alone.
Representative Ordonez,
Present, alone in the room.
Representative Muse,
Here and alone in the room.
Representative Newman,
Here and alone in the room.
Representative Bolden,
I'm present and I'm at home and my family's here.
Representative Conley, Representative Klein Knight,
Here, alone in the room, but my family's here as well.
Representative Bradley,
Here and alone in the room.
Chairman Abbas.
Chair is present. Representative Bolden, just for the votes we taken remotely, just make sure your video camera's on time to vote. I'll also just state that I did receive a message from Representative Gathright. She's running about 15 minutes late. Also, Representative Conley is anticipated to be present as well. He would be here around 9:45. I will now recognize Representative Marston to lead us in the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Amen.
Thank you, Representative Martin.
Thank you.
At this time, we open the public hearing on CACR 8. Chair will call Representative Terry Roy.
Good morning, Chairman, honorable members of the committee. It's good to see all your smiling faces again so soon. I am introducing CR 8. It's a mouthful. This is an amendment, a proposed amendment to the New Hampshire Constitution that would prohibit the legislature of New Hampshire from making any new restrictions on the right to keep and bear arms beyond those which are already or will be codified in federal law. The reason I'm introducing this bill is because I've heard from many constituents that they're frankly a little tired of every 2 years or 4 years or whatever it may be that power shifts in the State House, that they are concerned about either losing or having their civil rights infringed upon based on whatever political winds are blowing in Concord. Now, we all have our beliefs on the Second Amendment, and I respect everyone's view on it. So I'm representing my constituents. And the reason I left the federal law portion in there is because I'm also a realist and I understand the federal supremacy. So if the federal government says in its ultimate wisdom that you can't have magazines more than 10 rounds, well, that's the law of the land until such time as we can get the Supreme Court to rule otherwise. But if it doesn't say that, that would restrict New Hampshire legislators from making any laws, for example, on 10-round magazines. If it's not restricted by the federal law, we can't touch it. It would also prohibit New Hampshire law enforcement from enforcing any federal laws that ran afoul of our own Constitution that allows us to keep and bear arms. For example, if the federal government decided that, you know what, we're not going to allow semi-automatic handguns, well, the Hampshire Constitution would not agree with that, and our law enforcement could not enforce that. That doesn't mean the federal law enforcement officers in New Hampshire couldn't enforce it. It just means that our law enforcement couldn't enforce it. And again, back to the original goal of this is to keep people from having to worry about their civil rights every time that the legislature swings in Concord. And I hope that people who have a different view of this will consider the same thing happening with other civil rights that they are concerned with. If every time, you know, the Republicans took over, we tried to take away freedom of speech or the press in contravening federal law, your constituents will be equally upset and have to worry every time. So that's the basis for me submitting this, and I'm open to questions.
Representative Testerman.
Thank you. Thank you very much for taking my question. I was reading the legislation, and you're saying that if the federal government put a 10-round limit on magazines, we would have to live with it. Can't we enact an agreement that would, or a law that would sort of preempt the federal government? You know, there is that 10th Amendment that says, you know, the states have rights, and I'm a little bit worrisome about this.
I agree, and if I had my druthers, I would say yes. But I'm also a realist. I understand how the system works, and if they did enact such a law, and the Supreme Court upheld it, that we would really have no avenue. We can pass all the laws, you know, saying no, we're not going to obey the federal government all we want. the only recourse we have is to the Supreme Court, and the Supreme Court finds it constitutional and it applies to the states, our law isn't worth the paper it's printed on. So my goal was to try and keep this realistic. There are many states out there, and I admire them for doing so, that have made themselves so-called Second Amendment sanctuary states. And if we could, that'd be great. But in the real world, if the United States Supreme Court says that a federal law is constitutional and it applies to the states, our sanctuary law really just doesn't have any power. So I understand your concern, Representative Testerman, and I'm with you, but I was trying to keep this realistic for now.
Thank you.
Representative Knight?
Thank you, Chairman, and thank you, Representative Roy. I'm glad you brought up taking away people's rights every 2 years, and based off of the concern of the political climate in Concord and how it's not fair to our people and how we would feel if that would happen to us every 2 years. And I have to say that I think this pales in comparison to taking away the right to being able to choose on my own person, my own body, what I can do with my own health. I think that you still have the right to bear arms and protect yourself, no, in this state? Is that correct?
Is your question, do we have the right currently? Yes.
Representative Knight, I just asked you, I recognize you for a follow-up, but not to state questions.
Okay, I withdraw. Thank you. That was good enough.
Representative Muse.
Thank you for taking my question. The wording in the actual bill seems to be broader than what you described. It says that any federal law that infringes upon rights guaranteed in the New Hampshire Constitution shall be unenforceable by New Hampshire law enforcement. Any federal law?
Are you suggesting that it applies more than to this particular amendment of the Constitution? In other words, are you suggesting any federal law that has nothing to do with firearms? Is that what you're asking?
It would appear to be that broad.
Well, considering where it's placed in the amendment of the New Hampshire Constitution, I would assume a court would rightfully infer that that's what it's talking about. But Representative Muse, I'd be happy for you to submit an amendment to narrow that to just gun laws if that's how you feel.
Thank you.
Representative Newman.
Thank you, Mr. Chair, and thank you, Representative Roy, for taking my question. If the Supreme Court were to say that your Second Amendment sanctuary laws are unconstitutional, what effect would that have on this amendment to the Constitution?
The effect on it, I suppose, would be that we would still be limited from passing laws that were stricter than the federal law, but I think it wouldn't have any effect on it because that's the way I wrote it, so that federal law still was supreme. So if they say, for example, federal law is that you can't have anything more than a 10-round magazine, this amendment to our Constitution would prohibit us from making a law stricter than that, saying you can't have anything more than an 8-round magazine. But anything that we put in the Constitution to say, well, no, we're going to disregard that, would really be a null law. It'd be moot because the Supreme Court's ruling on this Constitution is what it is. And the only way to overcome that would be to pass a constitutional amendment to the U.S. Constitution.
Thank you.
Representative Bourdonnais.
Thank you, Mr. Chairman. Thank you, for Representative Roy, for taking my question. I'm a little concerned about, there are federal laws right now that restrict the carrying of firearms on school property, for example, to only people that have concealed weapon permits. But our state laws sort of forbid school officials as well as municipal parties from restricting any firearms regulations. Is that not true? And does that mean that those laws need to be taken out?
Well, so currently, you are correct. Federal law says that no one can carry a firearm on school property unless they're licensed to carry a firearm. We have legislation that says that the state has the ultimate authority and sole jurisdiction to pass firearm laws, so that school boards and towns, et cetera, cannot enact their own firearms laws. I do not think that were this to pass, that would matter, because they already can't. Am I answering your question right? In other words, this doesn't affect a law that says no one below us can pass firearms laws already.
Representative Bourdonnais, you are recognized for a follow-up question.
Thank you, Mr. Chair. Actually, you basically said in your testimony that if the federal government passed a law that restricted the number of whether you could have a automatic pistol or not, then the state would have to enforce that law, would have to abide by that law. Since federal laws already are more restrictive on use of the regulation of firearms on school property, would that not also mean that those laws are no longer valid?
I think I understand your question, but I don't think your premise is correct. Currently, there is no New Hampshire law that contravenes federal law. Federal law says that you cannot carry a firearm on school property unless you're licensed to do so. If a school board decides that they want to make a law that says you can't carry a firearm even if you have a license, that's what's prohibited right now by New Hampshire law. They're not allowed to pass laws regarding firearms on school property. So the New Hampshire law follows federal law right now with regard to having to be licensed to carry a firearm on school property. I'm happy to take another one from Representative Bourdonnais, because he looks like we're still not getting to the heart of his question, if that's what he'd like.
It's Representative Roy, we are as practice of the committee, we're doing our best to limit members of the committee to 2 questions per witness due to time constraints.
Well, I'm sorry, Representative Bourdonnais, if I didn't get that one, email me and I'd be happy to respond.
Representative Bourdonnais, do you have a third follow-up question you wish to ask?
Just a point. Maybe
remotely can speak. We're having trouble hearing you, so it is in the discretion of the chair to allow a third question, but I actually couldn't hear your first or second question, so I'm going to allow the third question. Just try to speak up.
Okay, so federal law already prohibits the carrying of firearms on school property unless you have a concealed permit.
Yes.
However, local law enforcement is unable to enforce those laws, only federal law enforcement. That's not correct.
I do not believe that is correct. I believe that, for example, here's another example. Sawed-off shotguns are illegal under federal law. So are machine guns. I believe a law enforcement officer can arrest on that. I believe so. Yeah.
Only in the absence of text.
Seeing no hands raised, I want to thank the representative for his testimony.
Thank you.
Before we begin calling members of the public, I just want to remind the members of the public, and this will apply to all hearings today, that testimony will be limited to 2 minutes per witness testifying, with the exception to the sponsor of the bill or the representative introducing the bill. Tracy Burkett Hahn.
Hi, thank you. Sorry. It's Han Burkett. Can you hear me?
Yes, we can.
Okay, thank you. My name is Tracy Han Burkett, and I'm here on behalf of myself and the Kent Street Coalition Working Group on Gun Violence Prevention, which I lead. Thank you for allowing me to address the committee today. I will make this very short. In terms of public policy, it's hard to think of a worse idea than adopting a blanket prohibition on any type of measure whatsoever that might improve safety with regard to firearms or frankly, anything else. I do understand that some of us want less government than others, but it is a legitimate interest and function of government to look after the health and safety of that government's people. And to wholly exempt firearms, which are deadly weapons, from the purview of all future laws, frankly, to me, is nonsensical. And I will just add that I do understand the frustration with having to revisit every 2 years a certain body of law. And frankly, it's a frustration that we share frequently. But that is the legislative process, and nobody understands that better than all of you sitting as a legislative body. And that's simply the nature of the lawmaking process. People do get shot and killed in New Hampshire, despite what's frequently all the testimony that we hear and all the words that we hear about New Hampshire being such a safe state. Some of those people do die. In particular, the rate of suicide has risen in a striking manner over the past decade. We do need gun violence prevention laws because it turns out that they do save lives. So let's debate the merits of individual proposals instead of blanket and frankly unconstitutional measures like this one. And I don't have any more time, so I can't get into that, but thank you for taking my testimony.
Thank you for your testimony. Seeing no hands raised, I excuse the witness. Calling the next witness, Leonard Korn. Welcome back, Mr. Korn.
Where did he go? Oh.
Can you hear me now?
Yes, we can.
Okay. Yes, I'm Leonard Korn. I'm here representing the New Hampshire Medical Society and the New Hampshire Psychiatric Society. And let me add, thank you for listening to my testimony. I'm also representing the American Medical Association and so many medical societies in the country that are interested in gun violence prevention, and I'd be glad to provide the committee with the 75 or more societies if anybody's interested. I'm here to express my grave dissatisfaction with this proposed amendment and to the many attempts this year and other years to propose gun bills that interfere with the US and state governments' attempt to rein in gun violence in this country. Rather, this bill and others unfortunately foster gun violence in our country and in New Hampshire. To be frank, I feel that the Republican Party is mostly lockstep in opposition to sane attempts to curtail gun violence and to provide for safety in our society. These efforts fly in the face of two key facts. Fact number one, numerous studies have demonstrated that loose gun laws are associated with more gun violence, and reasonable gun laws restricting gun violence are associated with less gun violence, less murders, less suicides by guns, and less gun injuries. The second fact is that the US has approximately 25 times the gun violence, and here I'm referring specifically to homicide, but also suicide of other Western democracies relative to guns. Let me close this brief testimony encouraging all representatives to vote to oppose this amendment and to be on the side of sanity and safety in our communities, in our state, and throughout our country. One further comment. Proponents of this amendment state that they are concerned regarding civil rights, namely their concern of expansion of interpretations of the civil rights related to the Second Amendment. However, the civil right of being alive and safe in our state, safe to remain alive, safe to vote, safe to breathe, safe from being shot, is clearly more necessary than focusing only on having more guns everywhere. Please vote against this violence-prone legislation. Let us have a state and country focused on love and caring for others. Thank you for listening to my testimony.
Thank you, Mr. Corn.
Doctor.
Excuse me, Dr. Corn. Seeing no hands raised, the witness is excused. Dina Romero.
Can you hear me?
Yes, we can.
Thank you. Good morning, members of the committee. Thank you for hearing my testimony. I have also submitted written testimony, which I hope was passed out to you. I am against this amendment because for the following reasons. It unnecessarily pits New Hampshire state law against federal law and sets a negative precedent. In vetoing proposed gun legislation last year, Governor Sununu said that the New Hampshire Constitution, and I quote, provides what many believe to be more expansive legal protections for gun ownership than the Second Amendment to the United States Constitution. The right to keep and bear arms in New Hampshire, cutting off debate on gun rights by limiting the ability to pass gun safety laws would silence the many New Hampshire residents who believe and want sensible gun laws. The proposed amendment ignores the fact that gun violence in this country is a significant public health crisis and a leading cause of premature death. The proposed amendment is overly restrictive with the intent of silencing a much needed conversation on sensible gun safety laws. This is not how democracy works. I wanted to add the representative presenting the bill talked about people worrying about their civil rights. I quite frankly am more worried about my physical safety if this amendment were to be passed. And I think it's time that we prioritize physical safety. I also wanted to mention that in other rooms this morning, there is discussion about the sanctity of the
Ms. Romero, we have to limit testimony to 2 minutes per witness. You've exceeded your time limit. If you don't mind just concluding your testimony with a single sentence.
I can finish my sentence.
I just asked that you conclude your testimony.
Yes. So what I was saying is there's a lot of emphasis on the sanctity of the life of the preborn. And there's less discussion on the sanctity of those of us who are already on this earth and being safe from gun violence. Thank you for listening to my testimony. I hope you will read my written testimony. Please vote against this amendment.
Thank you, Ms. Romero. Seeing no hands raised, the witness is excused. And for any members in the public that are in attendance, right, that wish to testify, please raise your hand now. It will please the chair and allow the committee to actually manage its time better, knowing how many people wish to testify in the public. Next witness is Sarah West.
Hi, can you hear me?
Yes, we can.
Hi, my name is Sarah West. I'm a student at Concord High School, and I'm representing the New Hampshire High School Democrats. We are deeply concerned about CACR 8 because it would prohibit the legislature from enacting common sense gun control laws. And doing so, sorry, I cut out. Can you hear me?
Yes.
Great. Gun control is a public safety issue, and we are terrified about the prospect of this amendment. As a student, I'm also keenly aware of the fact that there aren't enough common sense gun control laws in New Hampshire in the first place. When students walk into school, one of the first instincts is to see where the best place would be to hide in the event of an active shooter scenario. This is not an abstract fear, because we were trained on gun-related lockdown drills before we could write our own names. I hope that members of this committee consider the safety and well-being of students and other Granite Staters such as myself and oppose CACR 8.
Thank you very much for your testimony. Seeing no hands raised, the witness is excused. The next witness is Deidre Reynolds.
Reynolds? You saw? Mr. Chairman, I don't see that name. I apologize. If Representative Muse, if you could take a peek.
We'll keep it going.
Looking for the name, I don't see any telephone. I don't see any telephones either. So
the next witness will be Alan Rice.
Yep, Mr. Rice is unmuted.
Mr. Rice? Mr. Rice may be having technical difficulties, so we'll move on to another witness. Dr. Joe Hannon.
I've asked him to unmute himself. Okay.
There it is.
Can you come up?
I just saw it on
Alan Rice.
Yep. Alan, Mr. Rice just texted me, said that he's switching computers.
All right, Dr. Hannon's having difficulties. So we're going to try a third witness, and hopefully this works itself out. J.R. Houle?
Good morning, Chairman Abbas. Can you hear me?
Yes, perfect.
We can hear you.
Not anymore.
Not anymore.
Joe Hammond's been.
You're muted. You muted yourself.
All right. I asked him to unmute again. Here he is.
Am I back? Can you hear me, Chairman Abbas?
Yes, we would ask you to speak up.
Okay. Good morning, Chairman Abbas and members of the Criminal Justice Committee. For the record, my name is J.R. Hull. I'm a former state rep and I live in the town of Dunbarton. I am here to testify in favor of the concept, but not the language of this bill. The current language has significant unintended consequences. I would like to see a bill that goes forward that doesn't have those consequences. We've heard from numerous members of the New Hampshire Firearms Coalition about the need for a Second Amendment sanctuary state, and this is potentially the right vehicle to do that, but the language that has been drafted and submitted has some technical issues. So we, myself, as well as the New Hampshire Firearms Coalition, stand in support of the concept, but not necessarily the language that is in this current bill. And with that, I'll close my testimony.
Thank you. Seeing no hands raised, the witness is excused. Michael Thornton?
Thank you, Mr. Chair, members of the committee. My name is Michael Thornton, Milford, New Hampshire, speaking as a member of the public. I am and have been a gun owner all of my life, 70 years. As a minor with supervision, naturally, member of the United States Marine Corps and Air Force. I speak in support of the concept, absolutely essential. The Second Amendment is being attacked so many different ways. However, the language of this bill is not quite there. The concept is absolutely essential. I please suggest that the committee support and have the bill language amended. Thank you very much.
Thank you, Mr. Thornton, for your testimony. Seeing no hands raised, the witness is excused. Daniel, it's up.
Yep, let's see him.
I've asked him to unmute.
There we go. Sorry. That should be better?
Yes.
Okay. Thank you, Mr. Chairman, members of the committee. For the record, I am Daniel Itza. I am currently residing in Manchester. I am former state representative and former chairman of Constitutional Review. The proposal you have before you for a constitutional amendment is good-hearted. It's of good intent. However, we must remember that when we are putting things into the Constitution, particularly the Bill of Rights, they should be general concepts, broad concepts, and not particulars. When you get into particulars, you tend to forget something. So I've been working on a better wording with former Representative Hull, and I think that we have something that is up to the task. But I want you to remember that what you are not talking about here is not particularly gun rights or the firearms rights, but it is the most fundamental of our natural rights, the right of self-defense and the access to the tools necessary for that self-defense and the defense of others. It is for this purpose that we enter into government and we delegate certain of these powers to the government, but the government cannot always be there. When you're alone at night on the road, the government is not going to be there. When you're asleep in your bed, the government is not going to be there. You need to have, every individual needs to have guarantee of their rights to defend themselves from all attackers. I'd be happy to take any questions.
Seeing no hands raised, the witness is excused.
Representative Muse?
Mr. Chair, am I recognized?
Yes. My mistake, Representative.
So one of the concerns that we've heard from some of the other folks testifying is the fact that this bill would also silence debate on this issue. And we have another constitutional issue that we need to worry about here, simply aside from the freedom to freely carry firearms. I guess as somebody who has worked on constitutional issues in the legislature, how do you respond to that?
Well, I assume that because you didn't state it, that the competing issue you felt raised is one of right of freedom of speech or debate. It certainly does not silence debate. The question at hand would be how you adequately protect individuals who feel themselves in danger from such a proposal. You have to remember that what those people are fearing is criminal acts, assaults by another person upon their person or their loved ones. No law, no constitutional amendment itself stops such an individual from aggressing upon another. Making sure that people don't have the power to defend themselves does not ensure that a criminal will not take up those arms regardless of any law that might be enacted.
Representative Muse, you are recognized for a follow-up question.
Thank you. Would you agree that in addition to the potential to prevent crimes, that laws of the type that this action might ban might also prevent suicides, prevent accidents, may contribute to fewer situations of negligence?
Not generally, no. Accidents are accidents. You can't prevent accidents. You have to remember, laws do not prevent crimes. Laws punish crimes. Criminals commit crimes, and they will do so regardless. What you need to maintain is the ability to punish those who commit acts of injustice upon others.
Representative Muse, we're going to limit the 2 questions, each member to 2 questions per witness. I allow the exception Representative Borden because the room actually couldn't hear his question, so I couldn't access the discretion. Does any members have any additional questions? Seeing no hands raised, the witness is excused. Calling next witness is Alan Rice.
Mr. Chairman, I apologize for those earlier technical difficulties. Mr. Chairman, members of the committee, for the record, my name is Alan Rice, and I am a legal resident of Bedford, New Hampshire, and I am here as the State Director for Gun Owners of America, a national organization representing over 2 million firearms owners. I had sent the committee a letter explaining our concerns with CACR 8. We believe the way this is written, if it were to be enacted as written, it would actually set New Hampshire up for more gun control. Maybe not gun bans, but certainly gun taxes, because the language says that would create a greater burden than that in federal law. Federal law currently taxes handguns at 10%, rifles, shotguns, and ammunition at 11%. New Hampshire could tax them at 9% and 10% respectively, and that would not be a greater burden. So unless this is amended and that language is stricken, we would be forced to oppose CACR 8. Right now, we're neutral and hoping that this committee, through its wisdom and collective knowledge, would amend it. But in response to the people who are claiming mayhem and blood would happen, I would say look at constitutional carry. They predicted that, and we have not had any problems over the past 4 years. So they're just factually wrong. I believe I'm under time, and I'm going to conclude on that note.
Thank you, Mr. Rice. Seeing no hands raised, the witness is excused. Is Dr. Hannon still in attendance? His hand was up. It's not up now, but.
Mr. Chairman, I do not see him on the list anymore.
Is there one member of the public that you called that you? Teacher Reynolds?
Mr. Chairman, I do not see that name either.
She's the one you couldn't find.
Just call him again just to make sure. Yes. Seeing no members of the public with a hand raised, at this time, the public session on CACR 8 is adjourned.
And Mr. Chair, the sign-ins for House Bill CACR 8, 35 people signed in to support it, 166 signed in against it, and 1 person signed in as neutral.
Thank you, Representative Muse. Just a reminder, the next hearing scheduled for today is at 10 a.m. So we will see a recess for approximately 8 minutes. we'll open the public hearing on House Bill 195. Is the representative signed up to introduce the bill? Sorry. Floor is yours. You know where the hot seat is?
Yep.
And do your best to speak up as loud as possible, just to make sure the microphone and everyone can hear you. We won't accuse you of yelling.
Would you want me to face this way?
Yes.
No, we prefer that just so the public can see you, but you may speak as loud as you can even yell. We won't hold it against
Should I
you.
do this like this? Sideways?
Sit at the desk. Oh, sit at the desk.
All right. Hello, Mr. Chair, members of the committee. Thank you for inviting me back again. My bill, House Bill 195, is a simple bill, but feel welcome to spend any time you want on it. It is just one liner. It's just one sentence. It clarifies something in RSA 631, subsection 3. Something on reckless conduct, saying that displaying a firearm shall not constitute reckless conduct under this section. That's the gist of the bill. This is something I believe will save a lot of lives, because as we know, throughout the United States, defensive use of a firearm, or maybe just speaking about it, saves about 2.5 million lives every year, according to CDC statistics. So this is the gist of the bill, and if situation can be de-escalated, if there's a conflict that may arise, hopefully telling them that you're serious will calm things down and let everybody go peacefully. And that's what my bill does. It clarifies something in this section on reckless conduct. Thank you all. I'll be happy to answer questions.
Representative, thank you for your testimony. Representative Hopper.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. Was there an instance or instances that motivated you to bring this legislation forward?
Yes, actually in New Hampshire, I believe in Manchester, there was an instance where a lady was coming home from work, second shift, and she came under some sort of an attack, walking to the house, and then her husband awoke in the middle of the night, ran downstairs trying to help her, as he should have done, and I commend him for that. I believe he grabbed a pistol to go investigate and save his wife. He probably was not wearing a holster, probably was not, the pistol was probably not being holstered, he probably just held it in his hand, and he may have not even be wearing pants at that point. And I believe he got into some sort of trouble with the law because his firearm was not holstered properly. He was just holding it, trying to save his wife. So this hero should not be facing any kind of criminal danger, any kind of charges, because he was there to help his lady, as all of us would have done.
Thank you, Representative.
Thank you.
Representative, the chair has a question, and one question I have is, so I guess with the term displaying, I read displaying to be, it's included in part of the definition of brandishing, but it's not in and of itself brandishing. What would you define or understand displaying?
I don't believe it's defined as a statute, but it's a common English word. And when I looked it up in the dictionary, displaying saying display is word meant to show or exhibit, to make something visible, deliberately with an intent, as opposed to being reckless, where you have no intention, you don't know what you're
We
doing.
can't hear the witness.
All right. Yes. Yes. Yeah, to display, as defined in the dictionary, is to show or to exhibit, to make something visible. That's not being careless. That's not being reckless. You know what you're doing. That's your intent. You're doing it carefully. You're doing it deliberately. that's what the display is.
Thank you, Representative, for taking my question. Representative Gafford?
Thank you, Chair. Thank you for taking my question, sir. Given the example that you gave of someone coming to protect their wife, would you call that a display?
I couldn't hear the first part, I'm sorry.
You gave an example.
Yes.
Of a man going to basically to protect his wife.
Yep.
That's not a display, as your description gives. So what would you call that?
That's a display. He had his firearm in his hand.
But, can I have a follow-up?
Representative for a follow-up question.
Thank you.
Okay, but what was the intent?
The intent? He was there to save his wife.
Okay, thank you.
Yeah.
Representative Green.
Thank you, Mr. Chair. Thank you for taking my question. If a person was on a highway and there was about to become road rage, if he displayed his firearm, this would protect him as well as his family?
I believe so, and it would actually protect the attackers too, because they may think otherwise and go elsewhere, seeing that they don't want to continue with the confrontation. It would de-escalate the confrontation, I believe, and he would, right, his family and himself would proceed towards their destination.
Thank you for taking my question.
Representative Pantelakis.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. This seems like it's going to be that you can banish a gun or point a gun at anybody at any time, and it will not be reckless conduct. Am I correct?
So the subsection, thank you. The subsection 631:3 talks about reckless conduct, and that's not being reckless when you deliberately and carefully something. So that's what displaying is. Again, it is a verb. It is to show or exhibit something, to make it visible. Thank you.
Thank you.
Representative Welch?
Yes, Representative, are you aware of the statute that talks about display of a firearm in order to fend off an attack?
Thank you. Yes, I am. This is part 631:4. Yes. This talks about, right, this talks about displaying a firearm or other means of self-defense shall not be criminal under section 631:4. So that's a criminal, right? What I'm doing on section above it, enhancing or clarifying the section above it on reckless conduct.
Representative Welch, you're recognized for a follow-up question.
I was the author of that statute.
Okay.
It was a result of a fellow named, I think it was Ward Bird of America. Now, the display of his firearm resulted in him getting convicted. I was really upset over this. And the display was, he had the gun in the back of his pants. And when he turned around to walk back into his home, the woman who had gone through all kinds of no trespassing signs turned him into the police, and she was struck.
Yeah,
So
yeah.
That was why I wrote that. I'm a supporter of what you did.
Thank you. Thank you so much. Thank you.
Representative Burt.
Thank you, Mr. Chairman, and thank you, Representative, for coming today. If I'm understanding the bill correctly, if I'm walking down Elm Street in Manchester and somebody jumps out of an alleyway and wants to threaten me and my wife, and I feel instead of shooting them, I just show my gun and that will scare them away, that is acceptable. But if I also want to drive down the road, nobody's making me nervous or anything, and if I start just pointing my gun, this is what I'm being told is going to happen.
Is there a question?
Yes. Thank you, Mr. Chairman. If I just start pointing my gun, there is also a law against that. Your law is going to protect my first scenario, not my second scenario of just driving down the road pointing guns at people.
Is that Still waiting for the question.
Oh, so is that correct, that the first part of my,
Yes.
it's going to protect me, but there is also other laws that will stop bad behavior, like driving down the road pointing guns?
Correct.
Yeah. All right, thank you, sorry for being confused.
And I'll just remind the members, I'm sure we're gonna have a very healthy discussion during the executive session. I already had to warn 2 members of, just want to keep it equal. Representative Muse.
Thank you for taking my question. It does appear to me that the situation that you brought up, based on what Representative Welch was saying, is actually covered in New Hampshire law. What I'm curious about is what you think the impact of a bill like this would be in a road rage situation, where normally 2 people might get outside of a car, yell at each other for a couple of minutes, get it out of their system, jump back into the car and drive away. If somebody brandishes a gun or a firearm and the other person is also armed, but maybe armed so that they're concealed, doesn't it seem to you that something like this just opens the door for a much larger extent of potential gun violence on our roads?
Thank you for the question. Well, this is America, and we support and defend the Second Amendment, so anybody should assume that everybody is armed at all times. To display a firearm will just remind people, to warn them off, basically, from trying to escalate the situation. So I believe this would actually calm the situation down and allow the people go peacefully. Because it's just a reminder, again, this is America, this is not some other place. So I believe that this will de-escalate the situation. Thank you.
Representative Bradley.
Thank you, Chair, and thank you for taking my question. So you mentioned intent. Can a display of a firearm cross into reckless conduct?
Thank you. Well, so reckless, would it cross into? A display has deliberate intent in it. You're trying to exhibit, you're trying to display it, you're trying to show it, I'm sorry. You're making it visible. Reckless is defined elsewhere. If it's in the same subparagraph, but in the dictionary, if you look at reckless, it's got little to do with being displayed. Display is to make visible. Reckless is conduct where you don't care about your actions, where you're behaving carelessly, without caution. So reckless conduct, right? So they are separate, different verbs, basically. Display, yeah. Thank you. Hopefully.
Just to help guide the members of the committee, I believe this won't appear on the bill that was printed out, but RSA 631 3, if you look at Roman numeral 1, there is a definition of reckless, so that may be helpful to members of the committee. Representative Knight.
Thank you, Chairman. Thank you for taking my question, Representative. You mentioned it's more of a fear aspect, and people should be allowed to brandish a weapon for intimidation and safety purposes that way, not necessarily using the weapon. Is that correct?
Thank you for the question. Well, if it's me on the other side, and I don't suppose it'll ever be, but if somebody wants to show me their firearm, I'll be very happy about that. I will appreciate it very much, because I'd rather to be warned than surprised.
Follow up?
Representative Knight, you recognized for a follow-up question?
Thank you. So what you're saying, these people don't necessarily need to be trained, and you're okay with an exorbitant amount of public population carrying firearms just to scare each other?
Thank you for the question. I'm okay with it being America and people defending and protecting and using their Second Amendment right. That's why I came to this country. That's why I'm here. So we have the right to bear arms, and that's it. Thank you.
Representative Newman.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. Are you aware that in the 631:3 reckless conduct, the Roman numeral 2 says reckless conduct is a Class B felony if they use a deadly weapon, and all other reckless conduct is a misdemeanor? Are you aware of that?
Thank you for the question. Yes, I see it right here, yes.
Representative Newman, you're recognized for a follow-up question.
Thank you, Mr. Chair. Do you believe that based on Roman numeral 2, that this might be that the legislative intent when this bill, when reckless conduct was passed, intended to make the display of a gun much more serious than any other form of reckless conduct?
Thank you. It's thank you for the question. I think we're confusing the two terms, reckless conduct and displaying, exhibiting something, an item, are separate things. Conduct is actual, reckless conduct is defined in section 1, and in the dictionary, it's doing something where you're not concerned about the consequences of an action. You're doing something without caution, you're doing something carelessly. Displaying is an action where you show an item, where you exhibit an item. You have you know exactly what you're doing. So they are the opposites. Thank you.
Representative Conley.
Thank you, Mr. Chairman. Thank you, Representative, for taking the question. This committee heard a bill that you might know something about around expanding self-defense in a vehicle. And during the course of that testimony, we heard of a number of scenarios in which one would be then justified to use deadly force. And among the scenarios was somebody brandishing a weapon would then be perceived as threatening, which would then allow for deadly force. So if people are then brandishing weapons as proposed under this statute, do you foresee potential problems in which instead of de-escalating the situation, as it sounds like you're hoping, it escalates the situation into violence?
Thank you for the question. Good question. Good question. So the vehicle is a separate bill of mine. So my intent there was that if you're being kidnapped, carjacked, if you're being stopped from leaving, which is kind of being kidnapped, if you're cornered someplace, you are able to use deadly force to get out of that situation. Because in the vehicle, you can not leave all the time if you're surrounded by a bunch of folks, things like that. So there you're defending your life. And you got to do what you got to do. You know, you may step on the gas and get out, try to get out, even if you're trying, going to be falling off the road, something like that. So that's a separate deal of mine, right? So it would be, this doesn't talk about the vehicles. It doesn't talk about being threatened in that way. Let's see. Yeah, so if we're talking about the vehicle, the purpose of the vehicle is to go someplace, point A to point B. So you're trying to get out of the situation. You're again trying to de-escalate, to do whatever is necessary to de-escalate it. If you're being threatened, there's a, yeah, well, yeah, it is.
Representative Conley, you recognized for a follow-up question.
Thank you, Representative. I didn't mean to interrupt your thought process, but maybe might be great. So would you agree, we also heard testimony, and I hate to keep referring back to another bill, but I do see them as related. we heard testimony in support of that bill, or from a member of the public in support of that bill, who clearly articulated witnessing someone brandish a weapon at them as a threatening act that would then allow for a threatening or a deadly force response. So I guess would you agree with that person who spoke in favor of your other bill and the concern that they raised about pertaining to this bill?
Thank you for the question. I think since there are two subsections in the chapter, I'm sorry, 631:3, where I'm trying to make changes, and 631:4, which talks about, I think, the scenario you're mentioning, where somebody has been attacked in a vehicle and they have to figure out what to do. That deals with criminal threatening. That deals with fear of being placed in, being placed in fear of imminent bodily injury or other things. So those are two separate subsections under the bill. So I think what you're getting into is the criminal conduct, and that reckless conduct is something different. The criminal behavior.
Thank you. Seeing no hands raised, the witness is excused. I want to thank you for your testimony and taking our questions. Thank you. Before we go up next, I just want to remind everyone, so there is a legal difference between displaying and brandishing. I don't mean to critique the question. I was going to say they can use interchangeably, but there is a slight difference. So this only says displaying. So I mean, I don't mean to be too technical, but I just want to make sure the public understands that, and it may create confusion with the question. I think brandishing would involve also displaying a firearm with the intent to threaten a person without any legal justification for doing so. Displaying lacks the intent to actually, one, you have a justification for doing. Two, you're not trying to simply threaten or intimidate someone without any just cause. That's the distinction. That's why when I asked my question, what does he understand displaying to me? Because displaying is part of brandishing. Penny Dean. I just want to remind the members of the public that their testimony will be limited to 2 minutes.
Yes, Chairman, thank you. Can you hear me?
We can hear you.
Okay, thank you. My name is Penny Dean, and I'm an attorney, and I won't go through all the places that I'm admitted in. But the gist of this is this is really designed to give people a safe harbor and to de-escalate situations, because there are all sorts of statistics by Gary Kleck, who's a very famous Florida criminologist, and others that say the simple display of a firearm sometimes can diffuse a situation. And although I'm not speaking for the representative that introduced this bill, I would expect that that's what this is designed to do. And it's also designed to keep people to having a safe harbor. Simply displaying a firearm should not be a criminal charge. There are some people who choose to carry concealed, and sometimes their clothing moves if they're in a checkout line or whatever, and it's visible. And the mere fact of having a firearm present, or what some people could say displaying it in that instance, should not be a crime. And so this requires what someone would call non-criminal behavior. In other words, inadvertent behavior, or the deliberate, in some cases, it can go both ways, of just showing another a firearm. And I would respectfully say this bill is needed. This bill is clarifying other parts of the section. And simply because some people may not like or care for firearms should not allow them to cause the police to bring criminal charges against those who choose to carry a firearm for self-defense. And I'm happy to take any questions.
Thank you for your testimony. If I just may ask one question. You see it, you probably heard me discussing the term displaying. What do you understand the term displaying?
Displaying is simply to show, or maybe to make someone aware of. Displaying can also simply say to pointing out or to draw attention to. in this particular context. So it isn't the pointing or threatening, it is simply the showing. So in other words, it isn't the case where I bring out a firearm and I say, I'm going to shoot you, or point it at your head, or do any type of other behavior like this. This is simply showing or drawing attention to the fact that you are carrying or possessing a firearm. It's not intended to decriminalize criminal behavior.
Thank you for taking my question. Representative Hopper?
Thank you, Mr. Chair. Thank you, Attorney Dean, for taking my question. Do you know of instances in the state of New Hampshire where somebody has displayed a firearm to de-escalate a situation and has been successfully prosecuted for doing so?
Sadly, I do. Sadly, I do. And I think this is needed to stop that. And in many, many cases, it destroys a person financially. It destroys them, maybe causes them to lose their job, and many, many other things, because the mere fact that someone chooses to carry a firearm in some particular occupations or situations may cause people to say, look what they do. So absolutely, this is going to save a lot of, I think, unjustified and unwarranted prosecutions.
Representative Hopper, you recognized for a follow-up question?
Thank you, Mr. Chair. Can you email the committee a couple examples if you have them?
I could I could email the committee public examples of other people's cases. There are some of my cases that clients wouldn't want any more attention drawn to, but I'm trying to think of cases that would be very clear. Let me think about that, and I will try to do that. What's the timeline for when you would want to receive these emails?
The sooner the better.
Always. Thank you. I think the one best example that we've heard about was the Ward Bird example. Because, for example, there are times when someone has a firearm either on their holster or carried somewhere else, that the mere shifting of their coat or something, someone will allege that this was designed to be a criminal act, that you just were showing me the firearm to scare me, when the person, all they did was simply shift a coat or do something else, showing that they have a firearm, or inadvertently showing they have a firearm.
Representative Welch?
Attorney Dean, the difference between display and brandishing, would you agree is if you remove the gun from the holster, that's brandishing. If you leave it in the holster and just open your coat to show him around, that would be a display. Is that correct?
In general, I would agree with you. In general, I would agree with you. The only situation that I could see where that might be, and I'm just trying to think of all scenarios, but in general, I absolutely agree with you. The only way I could see it different is there are a lot of females who carry firearms in not easily visible places. We might choose to then show them at a given point. But yes.
Representative Muse?
Thank you for taking my question. I guess my question is that this is a method of de-escalation appears to be something right out of a Wild West movie. So if you and I are having a disagreement, and we're having a passionate disagreement, and you're on one side of the table and I'm on the other side of the table, and you take a gun out and you put it on top of the table, I guess my question is how does something like that de-escalate the situation, especially if I have a gun?
Well, first of all, and this is one of the biggest examples that I give people, is that I attended gun owners in New Hampshire meetings for probably 16, 18 years. No, actually probably 20 years. And there are no more passionate arguments and discussions than you will see with gun owners who tend to be opinionated. Never once did anyone use their firearm to try and intimidate another person or make a point. And I'll guarantee you everyone in the room had one or two guns on them. And so to suggest that gun owners are going to do that is inappropriate, and I think respectfully incorrect. In the situation you're talking about, we look at what's called the totality of the circumstances. So if I were to say something as well as doing that, then you've got a different situation, but that's not what this is dealing with. This is dealing with the displaying it, not the saying more, because in the situation you're talking about, I envision the person saying something as well as taking their firearm out and putting it in between the two of us. I just don't see that as being protective of criminal threatening behavior. I don't see this bill as taking away all the other statutory protections we have for what I call threatening behavior with firearms. I think what you're suggesting is that this now means people can engage in criminal threatening. And I would respectfully say, sir, that's not the case. There are plenty other statutes that deal with criminal threatening behavior. This is simply the showing of a firearm, and it can be in a variety of situations. And I don't think what you're talking about, I think what you're talking about is a different cat, if you will.
Representative, you recognize for a follow-up question?
Thank you. In your opinion, would a law like this make criminal threatening more difficult to prove?
I think what it does is clarify what behavior is criminal and what behavior isn't criminal. Because what has happened with this law is you've had more what I think improper prosecutions. And I actually am thinking of a case right now, and it's the Stuart Uri case that I tried. It came out of Milford. And what happened was, finally, after this person had gone through, I think, 3 years of trauma, who knows how many legal fees, finally, when the alleged complainants got, or the complaining witnesses got on the stand, one admitted, well, he never pointed it at us. And of course, instantly the judge dismisses those charges. But until you can put these people on the stand and narrow down exactly what the person's alleged to have done, I think this is going to stop a lot of false prosecutions that should not have been brought to begin with. So I don't see it as allowing criminal threatening, because I think of the Uri case, we had 2 separate jury trials, both times not guilty, after just destroying that man and his family. And then the state still wanted to bring a 3rd charge against him. And fortunately, at the last minute, for goodness knows what reason, they came to their senses, maybe because the trial judge said, you're going to bring more of this crap in my courtroom, and they null-prossed it. So I don't see this giving what you might, or what some might argue, is a get out of jail free card for bad behavior. I just respectfully don't see that happening. This is simply the showing of a firearm, because once you add in more facts, like the person saying, well, you know what I'm going to do next, or something like that, they're not merely displaying, they're saying threatening words. And that's a whole different thing. I think that then we're clearly in criminal threatening land, and the person can be successfully prosecuted.
Representative Newman?
Thank you, Mr. Chairman. Just to clarify what you just said, in the hypothetical example of a woman that had a gun in her purse and was in an argument with someone and opened their gun and took it out and remained silent, would you consider that reckless behavior?
In the context, if the other party is threatening them, like let's say they're coming towards them or doing something that's threatening, I would not consider that. I would consider that displaying a firearm, because they're letting the other party know that they have a firearm. And unfortunately, bullies tend to attack the weak, and groups of people tend to attack the weak. And when they see that there is a firearm or other equalizing self-defense tool available, they may choose not to attack them. And so I think that it potentially, especially women who now, like me, I'm a little bit disabled in the sense I have a bad hip and a bad ankle now. I'm not the distance runner I used to be. So I can't run from a threat. I can't even walk fast from a threat. The bottom line is that we might help me and others like me to avoid an attack. and avoid a larger and greater criminal act simply by displaying the firearm, which essentially, hopefully, will warn away an attack from those who might have chosen to attack what they think is a defenseless person. So I think this is going to save a lot of criminal acts and, quite frankly, potentially save people a lot of injuries. And I go back to the Gary Kleck out of Florida, a criminologist, his research, and John Lotz and many others that show the mere presence of a firearm sometimes deters much criminal activity. But
Thank
more,
you.
oh, sorry, yes, sir.
Seeing no further hands raised, I want to thank the witness for her time and her testimony.
Thank you, and I would appreciate passage of the bill, sir.
Tracy Burkett Hahn.
Proceed.
Can you hear me?
Yes, we can hear you.
Okay, that took a couple tries. Hello again, I'm Tracy Hahn Burkett here on behalf of myself and the Kent Street Coalition Working Group on Gun Violence Prevention. I just want to say simply that regarding definitions and statutes, Section 2 of 631.3 states that reckless conduct is a Class B felony if a deadly weapon, as defined in RSA 625.11, Section 5 is used. And I want to focus more on the statutory definition as opposed to a dictionary definition. So that section says deadly weapon means that any firearm, knife, or other substance or thing which in the manner it is used, intended to be used, or threatened to be used, is known to be capable of producing death or serious bodily injury. Firearms obviously fit that description. And so the law there makes a point of stating that reckless use of a deadly weapon is a felony. And so my question there would be, why would you exempt firearms from that? Then you get into the definition of display. And so I think that that's a really broad term, and you get into a subjective definition of that, and you end up, I think, at a poorly drafted bill. It's a broad term that can be interpreted in a number of different ways, depending on who's holding the firearm, what they're doing with it, who's seeing it, where they are, what the context is, etc. And a lot has been said about this, so I don't want to go into too much detail. But is taking a gun out of its holster to show it to a friend a display that should be reckless conduct? I don't know, where is that person? Are they experienced? Is the gun loaded? Are you in a crowded place? And I think a lot of the different people in this room are going to answer those questions differently, define reckless differently. And the example that kept coming back to me, because it came up in this context in preparation for the election this fall. What about someone who's wearing a firearm?
Ms. Hahn Burkett, we have to limit testimony to 2 minutes per witness, so you've exceeded the time limit. If you don't mind just concluding your testimony.
Yes. So what about someone removing a firearm from a holster at a voting booth? Something a lot of people have had to think about this past fall. So thank you for the time, and I urge you to vote to ITL this bill.
Thank you for your testimony. Seeing no hands raised, the witness is excused. I get it right, Dr. Leonard Korn.
Hi, can you hear me?
Yeah.
Oh, good. So I'm here to provide testimony against HB 195 allowing displaying a firearm or a weapon. Now, as you've heard in other testimony, displaying can be interpreted in a lot of different ways. Display of a firearm, if you just have it in a holster, presumably is not displaying it. But if you remove it or if the context of the situation is that you are displaying it in the means of threatening somebody else, that is a slippery slope. And I would rather not include legislation that would allow this slippery slope to be a way to excuse a dangerous or threatening type of action. Now, I'm here, as I said in my previous testimony on the other bill, representing the New Hampshire Medical Society, the New Hampshire Psychiatric Society, the American Medical Association, and many organizations, medical societies that are interested in promoting safety rather than danger or violence. This legislation can potentially lead to dangerous situations. And the definition of brandishing will certainly be questioned if we institute a legislation allowing displaying. If we leave it the way it is, we'll be safer. So please vote against this dangerous bill. Thank you for listening to my testimony.
Thank you, Dr. Bourne. Seeing no hands raised, the witness is excused. Dina Romero.
Tina? Oh, it's Dina. I'm sorry. You did say Dina. Yep, she is here this time.
Hi, can you hear me?
Yes, we can hear you.
Thank you. Thank you for taking my testimony. My name is Dina Romero. I live in Hanover, New Hampshire, and I respectfully ask you to vote no on House Bill 195. My reasons are as follows. Number one, we're talking about firearms, and we refuse to acknowledge that a firearm is a deadly weapon and it has deadly consequences. The point of the firearm is to kill or seriously wound another person. Please, let's remember that when we talk about firearms. Displaying a firearm is not a neutral act. It makes an aggressive and threatening situation, it makes an aggressive and threatening statement, which could escalate a situation and result in violence. The person presenting the bill said this is America, and I would add this is New Hampshire and not the Wild West. Governor Sununu himself said that New Hampshire is one of the safest states in the nation. And let me remind you, Governor Sununu canceled his 2021 outdoor inauguration ceremony as a precaution against protesters carrying arms. I do want to make one other comment, if I may, Representative Abbas, committee chairperson, which is about the process. Would you allow me just a short 2 minute to do that, please? I was very and have been very impressed with the process of how you are taking testimony from people. But this is the second time an attorney has been allowed to speak and answer questions, an attorney who is definitely a pro-Second Amendment person. And I would respectfully ask you, in defense of the democratic process, that if you are going to allow a pro-Second Amendment attorney as much airtime as you have allowed this person, I think it would behoove you to have an attorney present who is a proponent of sensible gun legislation. Thank you very much.
Thank you, Ms. Romero, and thank you for your testimony. And I believe the witness, the attorney who testified, her testimony was to limit to 2 minutes. a lot of the time taken up was the witness answering questions. I did set some ground rules for today for time constraints. Each member is permitted to ask each witness up to 2 questions, with a third at the discretion of the chair. So a lot of the comments and testimony provided thereafter was the witness answering questions asked by the committee members. So if there is any other members of the public with legal background, they're also welcome to speak, and I would encourage people with a legal background to come before this committee. Your testimony is always helpful and insightful. Is there any questions of the witness? Seeing no hands raised, the witness is excused. Representative Deborah Alschiller.
Good morning, Mr. Chairman. Thank you very much. Am I able to be heard?
You're just fine.
Thank you very much. Thank you, committee members. House Bill 195 seeks to add a new qualifier to Chapter 631.3. As a refresher, that chapter begins like this: a person is guilty of reckless conduct if he recklessly engages in conduct which places or may place another in danger of serious bodily injury. And then follows with this: reckless conduct is a Class B felony if the person uses a deadly weapon as defined in RSA 625.11. If you dig into 625.11, you'll find that a deadly weapon defines as any firearm, knife, or other substance or thing which in the manner it is used, and this is the important part, intended to be used or threatened to be used, is known to be capable of producing death or serious bodily injury. So I pose this to you. If a person goes walking through the aisles of Market Basket, carrying a baseball bat around, not hitting anything, not necessarily coming near anyone, not saying anything, maybe just striding through, carrying it on their shoulder, do you think that behavior will cause alarm? Of course it will, because a baseball bat is something unusual to carry around the supermarket. It is not normal. It is an alarming behavior, and it should be. Let's say you go to a restaurant and the person at the table next to you pulls out their 10 3/4 inch Whalen survival knife with the serrated edge and the gut hook. They put it on the table for everyone to see. Why on earth would they do that? Ostensibly, the restaurant provides its own cutlery. That's an unusual item to bring to a restaurant. It's an alarming situation, and it should be. Those instances are examples of coercive control. They're actions taken to send a message to the people around them that the balance of power is in the favor of the weapon holder, because
Representative, I do have to limit testimony to 2 minutes per witness, so if I just would ask that you conclude your testimony with a single sentence.
Thank you, Mr. Chair. Those examples are examples of coercive control, and those create an unequal power dynamic. It's a form of violence. And as House Bill 195 seeks to codify coercive control as an act of intimidation to silence, as a silent threat. It breaks down boundaries, it threatens safety. And I ask you to vote inexpedient to legislate on House Bill 195 and not normalize the presence of firearms in all parts of our lives.
Limit testimony to 2 minutes per person. So I just ask in fairness to the public that we now conclude your testimony. Representative Bradley.
Thank you, Chair, and thank you, Representative, for taking my question. So we've heard a lot about the presence of a firearm as being a de-escalation method. Supposedly because its mere presence should threaten the other party into compliance of what the gun holder wants. Do you think someone simply showing a gun is a method of coercing compliance?
Am I still unmuted?
You're unmuted.
Okay, thank you. I thank you for the question. So coercive control creates an unequal power dynamic in a relationship. It is a form of violence. It's a key factor in domestic abuse and intimate partner violence. It's part of the pattern of behavior that perpetrators use to gain power and control. And coercive control is an act of intimidation. It's a silent threat. So when someone has a firearm, they don't need to brandish it. Its presence is a threat alone. Ask any victim of domestic violence whose abuser never pointed a weapon at it, but would take it out and leave it on the kitchen table as a warning. Or ask the victim whose date ended in sexual assault why they froze when a weapon came out of the glove compartment, just for show. Or ask a family member who lost a loved one to gun violence and how normal it feels to be around people who, to their knowledge, have no permit, no training, and for all anyone knows, no background check in acquiring that gun because private sales don't require them in New Hampshire. Nothing about any of those instances are improved with the presence of a firearm.
Representative Knight.
Thank you, Chairman, and thank you, Representative, for taking my question. You just spoke to domestic abuse in our state, and I was wondering, since I'm not sure how familiar you are with that subject, if you could clarify to us what this bill would do to domestic survivors in this state if this bill were to pass.
Thank you for the question. I will share with you through my work with survivors of domestic and sexual violence that the normalization of the presence of firearms in all parts of our lives is unacceptable. And it creates a threatening environment everywhere. It is not a de-escalation technique because we know that the coercive control of just the presence of a firearm is meant to send a message to the people around you that the balance of power is off and it's in favor of the person who has the gun on their hip, in the back of their pants, on their leg, in their jacket, because they've introduced an item that's unusual to their surroundings, to all of our surroundings, and they've created a circumstance where they've demonstrated they're comfortable with that threat being out in the community. They're comfortable being the person who is the threat. That is coercive control, and that is the kind of threat that people who have suffered domestic violence and intimate partner violence and sexual assault live with when they have experienced that kind of violence by perpetrators and then see it in their community in places where you shouldn't have to see it.
Representative Green.
Thank you, Mr. Chair. Thank you for taking my question. Would you believe that many people, especially some women, carry guns that are unloaded?
Would I believe that some women carry unloaded guns?
Yes.
I believe that the presence of a firearm, loaded or unloaded, increases potential for violence, as demonstrated by the CDC.
Thank you.
Representative also, the chair would like to ask a question.
Sure, thank you.
Can you explain your understanding of the difference between displaying and brandishing?
Yes. So displaying, in fact, I have called up the brandishing of a firearm is the way, is the use of the firearm as a threat. So to, wave it around. It's my understanding that is to take it out, put it on the table, to wave it in the air, to display it openly and be threatening about it, to use it in anger or excitement. That's brandishing. Display is showing it. So, if you and I are sitting at a table and you take your jacket off and you show me you have a firearm, that's a display. And I know automatically that, the person in power at that table is you, because you've got the deadliest weapon at the table.
Representative Hughes.
Thank you for taking my question. So if I can more or less paraphrase what you just said, brandishing is the use of a firearm when you're making a direct threat. And displaying would be using it as an indirect threat. But in either case, it would appear to be that you're using it to make a threat. Would you agree with that?
So I think I appreciate the question, but I really want to dial back to what we actually have in statute. And in chapter 625, semicolon 11, part 5, when we're using the definition of deadly weapon, it means a firearm, knife, or other substance or thing which in the manner it is used, intended to be used, or threatened to be used is known to be capable of producing death or serious bodily injury. So in our statute, we have already codified that we know that a firearm is capable of producing death or serious bodily injury. And what HB 195 wants to do is take that out and add it as a qualifier. So it doesn't make the guns any less deadly. It just makes the person using it that much more dangerous.
Thank you.
Representative, the chair would have a question, and I just want to thank you in advance for taking my question.
Sure.
And this, correct me if I'm understanding your testimony correctly. Are you saying that there's not any way to display a firearm without actually threatening someone at the same time?
My testimony is the presence of a firearm as a deadly weapon, which we have codified in our statute, we know to be capable of producing death or bodily injury. And when a firearm is present, it creates a situation of coercive control. And as has been demonstrated in previous testimony and in questions from members of the committee, the intent is to actually create coercive control. Whether that coercive control is intended to be de-escalating or escalating, there's actually no way to know what the person who is creating the coercive control, you don't know what their intent is. But we do know, because we have defined deadly weapon in statute as something known to be capable of producing death or serious bodily injury. So when you introduce that coercive control into the situation, there's no way for anybody else to know the intent you have for displaying or brandishing, because you have the most deadly, most lethal thing in the situation.
Thank you. Thank you very much for taking my question. You seem to be lobbying for we have a law which allows open carry. So you really seem to avoid all this coerciveness. We would be better off just always displaying our gun in the open, no carrying it under your coat or whatever. So are you saying that that's what you think is the better option?
May I ask who's asking the question? I can't tell. I'm sorry?
Representative Testament has been recognized.
Thank you very much, Representative Testament. My testimony here is against the adoption of House Bill 195, which seeks to create an exception for the display of firearms in RSA 631.3. So that's my testimony here today, is that we should not be amending 631.3 to create an exception for firearms.
Thank you.
Representative Knight?
Thank you. Question of the chair. I feel like,
Are you raising a point of order?
yes, can I please?
Point of order is recognized.
I think it's inappropriate for either side, whether we like what we're hearing or not, to insinuate another member is a lobbyist when they're a respectful member of our house. And I found that a little disrespectful, with all due respect. Thank you.
Representative Knight, I appreciate the point of order. I will just to address it. I feel the term when it was used by the Representative Kesterman wasn't intended to imply lobbyists. I think he meant it as a form of advocacy. If you swap the word advocacy or advocating with the word lobbying, I can understand your confusion, though, but I didn't perceive it that way. I don't believe Representative Kesterman meant it that way. And just to state for the public, the representative testifying is not a lobbyist. To clarify.
Thank you for that. I appreciate it.
Seeing no members with their hands raised, I want to thank the representative for her testimony.
Thank you.
Jackie Wolf.
Yes, I am a member of the Emergency Corps of New Hampshire. I am a registered nurse in Massachusetts, but now living in New Hampshire. Are you able to hear me?
Yes, we can hear you.
Okay, so I would like to say that in New Hampshire, one second, I'm sorry. The CDC statistics tell us that in New Hampshire, between 207 and 209 and 216 to 218, there's been 110% increase in deaths by gun ages 10 through 24 in New Hampshire. We are the state that is the highest increase in deaths by gun in the entire country, according to the CDC statistics. And that's my simple statement. I think I have great concern as a nurse who's worked with brain injured young adults in the past. And often those injuries were by gun, and ultimately often resulted in death of that young population. That's all I have to say.
Thank you for your testimony. Seeing no hands raised, the witness is excused. Mike Thornton.
Thank you, Mr. Chair, representatives. I am Mike Thornton, a Milford resident since 1993. I come to you as an individual. I am in favor of 195. The reason being is, absent that, I would have been forced to shoot a person. I was in the Lowell Dracut State Forest. A young man was in contravention of the rules of the forest, was discharging a lever action firearm. I happened to be the person he was shooting at. He said he thought he was shooting at a dog. He was shooting at the top of my pack. I flanked him. By the way, I'm a Marine, enlisted Marine, Vietnam, Air Force officer, Space Shuttle program. I came around his backside and I ordered him with nothing in my hands to drop his firearm. He levered the action closed and pointed it at me. I then drew my .45, showed it to him at a 90-degree angle away from him, and again ordered him, drop your weapon. That worked. I took his firearm to the Lowell Dracut police station, turned it in, and told the sergeant at the desk what had happened. In a case that I was not allowed to show my firearm until in extremis, I would have had to draw and shoot immediately. That is unacceptable. Somewhere between lies the answer. I am not asking to draw my weapon and to settle an argument. I am asking to be able to use a tool to.
Mr. Thornton, we do have to limit testimony to 2 minutes per witness. Your time has expired, so I just ask that you conclude your testimony with one additional sentence.
That's all I'm saying. It's a tool for de-escalation. I'm also saying that percentages can be manipulated. I'd like to hear the absolute numbers on that 110% increase. Thank you so much.
Thank you, Mr. Thornton, for your testimony. Seeing no hands raised, the witness is excused. There is a phone number, person that the hands raised, we don't have a name. We just ask that you provide your full name for the record, where you're from, and whether you are testifying in support or in opposition to the House Bill 195.
Good morning, Mr. Chairman and members of the committee. My name is Jay Simpkin. I live at 20 Cabot Drive in Nashua, New Hampshire. A couple disclosures. I'm a federally licensed firearms dealer. I'm also an international economic consultant. Generally, and I've only listened to part of the testimony, it seems that there's a concern that the display of a firearm somehow conveys threat. I understand that. The point I wish to address is this. A prior witness referred to some CDC statistics. The CDC is a huge organization and produces many, many hundreds of series of statistics. But the gravamen of the witness's testimony is that New Hampshire somehow is becoming a less safe place. I will cite to a very specific source, and it's a well-known source. It's a series published by the FBI called Crime in the United States. They've published it in its present form since about 1961. Data published in Table 4 under the heading of Incidents of Violent Crime show that in 2019, New Hampshire went from the third safest state in the Union to the second safest state in the Union. Again, this is incidents of violent crime per 100,000 residents. That metric means that the incidence is adjusted for population differences between the various states. From at least 2001 through 2018.
Excuse me, we do have to limit testimony to 2 minutes per witness. If you don't mind just concluding your testimony with an additional sentence.
Hello?
Oh, yes. We have to limit testimony to 2 minutes per witness, so if you don't mind, your time has expired. If you don't mind just concluding your testimony with one additional sentence.
I'm sorry, I could not hear that which you just said, sir.
We have to limit testimony to members of the public to 2 minutes per witness. Your time has expired, so the chair is just asking to inform you of your time has expired, but also allow you one additional sentence to just conclude your testimony.
Basically, if I have one sentence, it is this. New Hampshire is now the second safest state in the Union, with relatively few firearm laws, and any suggestion to the contrary defies the data as published by the FBI, which data are authoritative. Thank you, Mr. Chairman. I'll be happy to answer any questions.
Thank you for your testimony. So seeing no hands raised, the witness is excused. Dr. Joe Hannon.
I am here. Can you hear me? Hello?
Yes.
Great. Okay. Good to be here. Thank you very much, members of the committee, for listening to my testimony this morning. My name is Dr. Joe Hannon. I'm the Vice President for Gun Owners of New Hampshire. And we are in strong support of voting this bill ought to pass. We've heard that about the Ward Bird case in 2010. In response to that case, the criminal threatening statute was amended to add paragraph 4, which states, and we've heard, a person who responds to a threat which would be considered by a reasonable person as likely to cause serious bodily injury or death to the person or to another by displaying a firearm or other means of self-defense with the intent to warn away the person making the threat shall not have committed a criminal act under this section. The reckless conduct statute was also subsequently amended so that it was no longer subject to the sentencing provisions of RSA 651-2, Section 2G. Subsequently, Ward Bird's sentence was commuted in 2011, and Gun Owners of New Hampshire is of the mind that the proposed amendment to the reckless conduct statute comports with the sentiment behind the amendment to the criminal threatening statute. If a person threatens another with a firearm, they will be charged under the criminal threatening statute. But if they display a firearm with no threat, it ought not to be a crime. This bill will make people safer. It's better to warn than to act. This gives people the option. Displaying firearms are used much more often to prevent a violent attack than they are used to shoot in self-defense. And lastly, I'd like to just say, we've heard about different what is reckless and what is brandishing and other things. We know that driving is legal. Reckless driving is not. Driving on the shoulder is reckless, but swerving onto the shoulder to avoid an accident is not reckless and would be considered prudent by most. We should at least be consistent with our laws and make sure that our criminal threatening statutes are in line with our reckless conduct statutes and don't differ in any way from any of the other parts of our law. So I urge you to pass this, and I'd be happy to take any questions. Thank you very much.
Seeing no hands raised, I want to thank you for your testimony.
Thank you.
Representative Burke, is that the same phone number that was testified?
I believe so, Mr. Chairman. I did not lower their hand.
Chair Holt?
Hello, members of the committee. Can you hear me?
Yes.
Okay. Members of the Criminal Justice Committee, J.R. Hull.
Committee can't hear you. While you're having technical difficulties, we're going to move on to another witness. We'll call you directly after. At this time, we'll call Zandra Rice Hawkins.
Hi, can you hear me?
Yes, we can hear you.
Thank you. My name is Andrew Rice Hawkins. I'm the director of Gun Sense New Hampshire, a project of Granite State Progress. We oppose House Bill 195. This bill would exempt displaying a firearm from the reckless conduct law. That law currently states a person's guilty of reckless conduct if they recklessly engage in conduct which places or may place another in danger of serious bodily injury. It's very important to note that that is about danger of serious bodily injury. Reckless conduct is a Class B felony if a person uses a deadly weapon, or misdemeanor for all other reckless conduct. There's also provision that if the victim and defendant were intimate partners or family or household members, a conviction is listed as a reckless conduct domestic violence. House Bill 195 in its attempt to exempt displaying a firearm from the reckless conduct law, this dangerous move gives a free pass to anyone who wishes to recklessly display firearms to harass, intimidate, coerce, control, or threaten others, from domestic abusers to armed extremists. RSA 627-4 :2-A already allows a person who responds to a threat which would be considered by a reasonable person as likely to cause serious bodily injury or death to the person or another to display a firearm with the intent to warn away the person making the threat without having committed a criminal act. The bill before you is unnecessary and dangerous. It erodes basic personal liberties against armed intimidation and harassment and could allow domestic abusers more power. We urge you to vote it inexpedient to legislate. Thank you.
Thank you, Ms. Hawkins. Seeing no hands raised, I want to thank the witness for her testimony. Witness is excused. J.R. Hall, we are calling you again. We hope you resolve your technical difficulties.
Mr. Chairman, he just messaged me saying that he is on a telephone, but I have not seen his number. I could try to resolve this if you want to call somebody else, Mr. Chairman.
We'll call Alan Rice.
Good morning. Can you hear me, sir?
Yes, we can hear you.
Thank you. Again, for the record, my name is Alan Rice, a resident of Bedford, New Hampshire, and I represent Gun Owners of America, a national organization. I have submitted written testimony to the committee, and I just want to comment on some of the things that those who oppose this bill have stated. I think they have it exactly opposite. A victim of domestic violence, a victim of street violence, a shopkeeper. Yes, the presence of a firearm does reverse the balance of power and enables a victim to survive. This bill is about defensive display. Defensive display is not the same as brandishing. Brandish is to wave or flourish something, especially a weapon, as a threat in anger or excitement. Display is to show a prominent exhibition of something. Whether the firearm is displayed in a holster or someone's holding it in a low ready position, prepared to defend themselves, either way, that turns the tables on the attacker, and the victim probably won't be a victim. Defensive display should be specifically lawful in New Hampshire, and this bill would do that, and I would urge the committee to vote House Bill 195 ought to pass without amendment or change, and I'm happy to entertain questions. Thank you.
Seeing no hands raised, I want to thank you, Mr. Rice, for your testimony. The witness is excused. We have a phone number. Just please identify yourself for the record by stating your full name, where you're from, and whether you're testifying in support or opposition to House Bill 195.
Yes, good morning. This is J.R. Hull of the town of Dunbarton, former state rep. Good morning, members of the committee. Can you hear me?
We can hear you.
Yes. Okay. I am testifying on on behalf of myself personally, as well as the New Hampshire Firearms Coalition, in support of the bill before you. This bill will, in fact, allow gun owners not to be recklessly charged with criminal activity when there has been no crime. I think there's a lot of paranoia and fear mongering going on, and I want people to understand that the mere display of a firearm is not a criminal activity. The escalation of a heated argument, maybe physical actions on behalf of one of the parties in an altercation is different, and that's already covered under criminal threatening statutes. This is something where someone's jacket is picked up when they bend over at the store or something, and there you could have someone charged needlessly with a crime where there has been no crime. So I would ask that you would support this bill as filed with no amendments or changes. Thank you so much.
Representative Burt.
Thank you, Mr. Chairman, and thank you, former representative, for your testimony. So we've heard testimony, and I just want to clarify it one more time because I think you alluded to it. If a woman or a man, regardless of gender, wants to abuse their significant other and they pull a gun out, just set it on the kitchen table, there's laws against that, correct?
If someone is threatening another, there is an entire section of statutes that covers criminal threatening. It is irregardless of whether there's a firearm involved or not. It could be another tool like a knife, or it could just be based on sheer size. Women in particular don't have the same physical stature that men do, so they're at a technical and a tactical disadvantage if there is somebody who is much larger in stature who's making verbal threatening or comments. And this levels the playing field. So I hope I've answered your question, but it has nothing to do with the firearm. Criminal threatening is an act by itself, regardless of whether there's a firearm there.
Thank you.
Seeing no hands raised, I want to thank the witness for his testimony. Seeing no members of the public present with their hands raised, at this time we will adjourn the public hearing on House Bill 195. Moving forward, at this time, the Criminal Justice Public Safety Committee, we are going to open the public hearing on House Bill 307.
Mr. Chair, we also have we have sign-ins from the previous bill, HB 195. 42 people signed in support of the bill, 156 people signed in opposition, and no people signed in as neutral.
Thank you, Representative Hughes. Representative Norm Silver.
Yes, Mr. Chairman. Thank you very much, Mr. Chairman, members of the committee. Norman Silver, State Representative from Belknap 2, which are the towns of Guilford and Meredith. House Bill 307 deals with a rewrite of RSA 159:26, which we thought was our preemption or firearms preemption statute. This was passed several years ago in an effort to make uniform across the state that the state alone was the source of any firearms regulation. What has happened since its passage, it's only 11 lines long, and it has really very little enforcement mechanism. What's happened since the passage of 159:26 is that various and sundry government entities and even individuals operating government properties under leases and things of that sort have undertaken to adopt rules, regulations, ordinances that seek to regulate firearms, notwithstanding 15926. So the point of the HB 307 is the recitation that a recognition that New Hampshire is not a home rule state. We don't let the individual municipalities and lower government agencies and entities just decide what they want to do on their own. We haven't granted them that power. The power comes from the general court. The general court has previously said it wants to preempt all firearms regulation. But because of the weaknesses in 15926, I have brought forth House Bill 307, which makes it crystal clear in a lot more lines, unfortunately, than 11 lines of the original statute, and a lot more lines, that all firearms regulation must be done at the state level, not the local level. And it provides for an enforcement mechanism, and it provides for the ability of anyone who is aggrieved by passage of some of these basically unlawful enactments by local agencies to get them rescinded. And if not, relatively promptly rescinded, there are some financial penalties involved. So that's the whole purpose of this. It's really to make it crystal clear that when we adopted 15926, effective in 2011, we really meant it. So that's the whole purpose of HB 307. And I'll be happy to take any questions.
Representative Kesterman.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. Can you give us a couple of examples that exist right now of where this is the power has been usurped by a local, state, or schools?
Well, of course, there's been a wide publicity of the adoption of gun-free zones by local school boards within the state. I'd be happy to compile a schedule of all the reported instances of basically violation of 15926 by local entities. I don't have the whole list in front of me now, but I think we've seen a lot online. We've seen publicity of school board members saying, "Well, I'm going to introduce a resolution that we're going to adopt a gun-free zone in XYZ town or city." I'll be happy to provide the committee with a list after the testimony is concluded.
Representative Kesterman, you recognized for a follow-up?
What I was thinking of was the rules are particularly at UNH. You and I are familiar with UNH, unfortunately. But what about those rules?
Yes, I mean, if it's basically what House Bill 307 does not affect any privately owned property. But if it's government-owned property, if it's public property, then the public has the right to its Second Amendment rights and its rights under the New Hampshire Constitution and under constitutional carry, which the legislature has passed previously. And the people who are in control of whether it's UNH or Plymouth State or Keene State or any of these public institutions should not have the right. They do not have the right currently, but they just ignore the prohibition of 15926. Now, if you get into a private school like Dartmouth, they can do whatever they can prohibit whatever they want to. It's private property, but it's not government property. It's private property. And anybody that wants, if you go to a store and they want to put up, this is a gun-free zone, they're welcome to do that, but not a government-owned, publicly owned property.
Thank you.
Representative Pantelakis. You're on mute.
Thank you, Mr. Chairman, and thank you, Representative, for taking my question. My question is, are you saying that this law will fine the cities and towns if they don't obey it?
Yes.
And that fine will come from the state?
No. It should come from the people who pass the laws that they know are against the statutes we've already passed.
Follow-up?
Representative Pilakis, you're recognized for a follow-up.
And are you saying, I'm sorry, but I don't understand what you mean. Are you going to find the school board members or council members personally?
If they pass a local rule, ordinance, or a regulation that is contrary to the statute, yes, they should be subject to fines.
Thank you.
Representative Hopper.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. Do you know of anybody in the state of New Hampshire that violated one of those local ordinances that has been successfully prosecuted for the violation?
No, I do not.
Mr. Chair, if Representative Hopper could repeat the question, I was still writing the answer from the previous follow-up. I completely missed it.
Representative Hopper, can you just, the Madam Clerk would ask if you could repeat the question?
The question was, did the representative know of any instances in New Hampshire where somebody has successfully been prosecuted for violating a local ordinance on firearms, which is expressly against the state statute that says they don't have to pass those ordinances?
You want me to repeat my answer? My answer is no, I do not know of any specific instance, but the existence of those regulations or ordinances passed contrary to 15926 has a chilling effect on constitutional rights.
Representative Muse.
Thank you for taking my question, Representative Silber. As I understand your bill, it would appear to give any citizen of the state the right to bring a civil action against a community in violation of this provision. So if I'm understanding it correctly, if Hanover was to pass a law that violated this statute, somebody in Salem could bring suit against them. Is that correct?
Yes.
Representative Newman.
This is sort of a follow-on to Representative Muse's question. If in fact these new penalties that are put into effect for the individuals on boards like school boards and boards of aldermen and whatnot, do you have a concern that that would limit the number of people that would want to hold those positions?
It may have a limit on people who might want to serve on those boards to enact law, local ordinances and rules and regulations contrary to the state law.
Representative Newman, do you have a follow-up question?
Yes, I do. The other question I would have, in the case that Representative Muse brought up, where an individual sued successfully a member of a school board or whatever board, where would the funds go if they got money damages?
I would assume that they would go into the general fund of the state.
Thank you.
Mr. Chairman, point of order, please.
Representative Byrd, you are recognized for a point of order.
Thank you, Mr. Chairman. You know, I'm sure it wasn't intentional, but when a representative on the committee that is at home Zoom in ask a question, should they be visible? I know they have to be during voting. I just didn't know if they should be so the public can see, the representative asking the question.
Thank you, Representative Hurd, for the point of order. My understanding of the rule is that the video for the representatives participating at home must only be turned on when you're voting during the executive session. However, I would encourage the members participating from home to, when they ask a question, to turn their video on. I just think it's for a better hearing, but it's not required.
Thank you, Mr. Chairman.
Representative Conley.
Thank you, Mr. Chairman. Thank you, Representative, for questions. The fine mechanism envisioned in this bill seems like one way to address this.
I'm having trouble hearing.
Representative, I'll raise my voice. My apologies. Would it not be better to address this potential overreach, if we want to use that term, by allowing the voters of that community to respond by removing people who are doing things from the school board or town council that they do not agree with, rather than opening those people up to lawsuits?
That would be the case if we were a home rule state, but we're not a home rule state. And these actions are violative of state law adopted by the general court in a non-home rule state. Yes, the voters should turn the people out of office. That would be the normal result in a home rule state, but this is not a home rule state.
Representative Bournet.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. I'm looking at Section 8. It said that public funds will not be used to purchase insurance or defend any action or damages an attorney feel. This sort of a violation of the rights of those boards to help their members?
Indemnification of members of boards is appropriate when the members are accused of something, but is often not provided when they are found to have violated state law or a fiduciary duty. So in the case where they violate state law or a fiduciary duty, indemnification, whether it's in the form of insurance or any kind of indemnification provision that they have in their own local ordinances, would not be appropriate. They're violating state law. This is an intentional act. This is not something that is done simply by negligence. This is an overt action that they have taken, so that if it's an intentional act, insurance normally doesn't even protect, even liability insurance doesn't protect against intentional acts.
Thank you. Mr. Bournet, do you have a follow-up question?
Yes, I do. Thank you. Thank you, Mr. Chair. So if this organization, school board, for example, were to pass a ordinance against firearms, that would be as a collective, not as individuals. Would you be collect funds from each individual board member that voted for the ordinance, or would it come from each member of the board regardless?
Only those who voted in favor of contrary to public law, contrary to state law. If there's a member of a board who disagrees with the vote and states on the record their disagreement with the vote, they should not be subject to being fined.
Representative Muse.
Representative Muse, you're muted.
Thank you. Thank you for taking my question. Representative Silber, do you believe that the same standard that you're calling for local city officials should apply to state officials at the state level if they violate federal laws and federal requirements?
I don't know the answer to that question, Representative. That's, you know, I never examined that issue in the context of violating federal laws. I don't know the answer.
Seeing no further questions, I would like to thank the representative for his testimony.
Thank you for your attention.
At this time, the chair will recognize Representative Jess Edwards.
Thank you, Mr. Chair. This is Representative Jess Edwards representing Auburn, Chester, and Sandown. I just wanted to give a specific example that stuck out in our community. Shortly after passing the original law, we had the Timberlane School District, in violation of the law, pass their own anti-gun measures. And when I talked to some community members that knew that district well and knew the superintendent well, the feedback I got, and admittedly this is second, third hand, but the common sense approach to thinking about his action was that he was beyond having anything enforced on him, and Timberlane already hires attorneys. And so he had the taxpayers of his district ready to defend his illegal act contrary to state law. So I am in favor of 307, if not every word of it, certainly the concept. We have intentional scofflaws out there, and it's violating our citizens' rights. So I think we need to do something about it. I'll take questions if there are any.
Representative Green.
Thank you, Mr. Chairman. To Representative Silber, my question is, if you had a teacher that was trained and licensed to carry a firearm, the teacher would be able to carry this in school?
If that's for Representative Silber, I think I have the floor, but you can excuse me, Mr. Chair.
Representative Green, I need to direct a question to
either one.
Well, Representative Edwards is the witness testifying, so.
Please, Representative Edwards.
Could you repeat your question? I'm sorry, Representative Green. I was confused who was taking the question.
A teacher who was trained and licensed to carry a firearm, this would not restrict them from carrying that firearm.
I don't believe so. I think that's consistent with the law that the legislature passed and the governor signed.
Thank you.
Seeing no hands raised, I want to thank the representative for his testimony. Tracy Burkett. Tracy Burkett Hahn, excuse me.
Can you hear me now? Excuse me, can you hear me now? Hello?
Yes.
Okay. Tracy Hahn Burkett. I'm here on behalf of myself and the Kent Street Coalition Working Group on Gun Violence Prevention. I'm here to testify against HB 307 because it seeks not only to expand our state's existing preemption law, but it specifically targets schools and it severely punishes individual public servants for even attempting to save lives in their own communities. It's not a bill merely to promote pro-gun policies, but it's intended to wipe out any gun safety attempts and to do that with a vengeance. It would mandate that no public K-12 school or the New Hampshire university system as well as other public entities, could take any measure to prohibit parents, teachers, staff, visitors, or students from carrying or storing guns. And it would do this despite mountains of evidence showing that children's curiosity, for example, when they find guns, accidents that occur at schools with guns, substantial increased expenses by universities that must be borne by these universities when they're forced to allow guns on campuses, allowing high suicide rates among New Hampshire's young people, and more. New Hampshire education officials and others, they need the ability to determine how to deal with these problems. What they most certainly don't need is to have the legislature tie their hands behind their backs and threaten them with $100,000 in punitive damages for starters, and then forbid them to pay these punishments out of their insurance policies, all for the crime of trying to care for their communities. It seems like this whole morning has been about legislation designed to elevate the gun interest above any other interests. And this is just backwards and wrong-headed. Those who believe in the sanctity of the gun do have their rights, but other interests, including human interests, are just as important. I urge the committee to please remember that and to vote to ITL this punitive HB 307. Thank you.
Thank you for your testimony. Seeing no hands raised up, the chair will excuse the witness. Representative Horrigan, you're recognized by the chair.
Thank you very much, Mr. Chair. I didn't know my hearing and judiciary would get over in time for me to speak to this, and yours is running a little long. I'm Representative Timothy Horrigan. I represent the towns of Durham and Madbury. Durham is very significantly the home of the University of New Hampshire, and they may or may not have someone speaking. I don't see who's sitting in, you can't see who's sitting in the virtual gallery, but I know they're extremely not interested in allowing just anybody to carry guns on campus. I know that annoyed, I know at least one member of this committee sort of complained about this when we had the session days at UNH, especially since they do allow some people to carry guns. For example, we had a police presence at our sessions and even some members of the National Guard. So they want very much to be able to do the same thing Dartmouth or any private institution, so-called private institution does, which is be able to set their own rules for guns. They mostly ban gun into campus residences, classroom buildings, and they ban all sorts of other things that are legal. So the mere fact that guns are not illegal doesn't mean that UNH, like any other institution, might not want them to be restricted on their premises. So that's their theory is having fewer guns on campus is better for security. Not everybody necessarily agrees with that, but that's their decision. They should be free to make it just like Dartmouth. And actually, the amount of money that UNH gets from the taxpayers' percentages, it's about 10% from state funding, and then there's some federal funding. That's actually not that much different than what the private institutions do. Consider all the grants and the other things too. Also, I always find it's ironic with all those bills, we're always worried about gun owners inadvertently breaking the law. And so I'm kind of surprised. I mean, I'm not really into guns. I do own a car, which is also like a very expensive, very dangerous object, and I'm really kind of baffled that somebody who's into guns is somehow not aware. We can't expect them to be aware of the fact that guns aren't allowed everywhere or that laws are different in different places. So I've never quite understood that. I just know as a motorist, as somebody who likes to drive, I know my car's not allowed just anywhere. I can't just drive it just anywhere I want or park.
Representative Horrigan, we do have to limit testimony to 2 minutes per witness. If you don't mind concluding your testimony with a single sentence.
I think he's done, Mr. Chairman.
Representative Horrigan, have you concluded your testimony?
Oh, I'm sorry. Yes, I figured I pretty much finished. I mean, there's more I could say, but apparently I've used up 2 minutes. I didn't hear the announcement at the beginning. I came in before Representative Silber was speaking, so that's there's a lot of other reasons. I think a lot of the reasons why this is a bad bill, and actually educational institutions, they probably.
Representative Morgan, I'll allow you one sentence to conclude your testimony.
Well, that's it. I think especially educational institutions should be exempted from this bill, and the whole bill should be ITL. But even if you do pass it, you should leave out the educational institutions in particular. So thanks. Bye.
Seeing no, Representative Bourdonnais, you have a question?
Thank you, Mr. Chair. Thank you, Mr. Representative, for taking my question. Federal law already prohibits firearms on public school property. State law 159:26 prohibits school boards and municipalities from imposing regulations about firearms. This bill of 307 basically states penalties for violation of 159:26. Is it not true that school boards could actually ask federal law enforcement to enforce firearms on school property?
Basically, yes, but it's most states also have a state law that parallels that. I'm not necessarily the expert on it, but I have supported bills about guns on campus, so guns on school property. So it is a violation of federal law, but it would be better if we had a state law. And of course, this goes beyond the status quo and actually forbids any type of anti-firearms rules on school property. And that, as I said before, that's inconsistent with the fact that schools appropriately ban all sorts of things that are allowable outside premises of the school. And I think there's a good argument to be made that people should not be carrying firearms on the campus of any type of educational institution, except for certain purposes. So that's about the best answer I got there.
Representative Bourdonnais, you're recognized for a follow-up question.
Thank you, Mr. Chairman. So I know there is another bill that's in the legislature right now to allow state law enforcement to enforce federal law. In this case, then there will be a conflict between state law enforcement and federal law. And would the law enforcement agent or law enforcement officer have to choose which laws to enforce?
That's probably a good point. I can't really answer that in any detail. I can say that, as I repeat, which I guess I already made, but maybe I'll make it a second time as quickly as I can, that it's states that have guns in school that allow state school districts. In most states.
The witness will suspend. There's been a point of order raised. Representative Wallace, you're recognized for a point of order.
Thank you, Mr. Chairman. Presently, we're discussing House Bill 307, not the other bill, so I'd like to get back on the topic in front of us.
Thank you, Representative Wallace, for your point of order. I agree that we are currently the public hearing that's open right now is for House Bill 307. So let's try to keep the testimony narrowed to that. We do have a lot of members of the public waiting to testify. Representative Morgan, you may answer the question. Please limit your testimony.
Okay. I think I already answered both Representative Bourdonnais' questions as best of my ability. They're both very good questions. The second one, that's the subject of other bills as well. So it would be better. The school. It would be easier for law enforcement to enforce, problems with firearms on any type of campuses if we had a state law that paralleled the federal law, which most states do. So, and there's that's a subject. That's probably a topic for another day, and I'm not necessarily the best person to address the issue, but that's my understanding of it.
I respectfully agree with that statement. Thank you, Representative Morgan.
Oh, thank you. Thank you, Mr. Chair. So,
Seeing no hands raised, I want to thank the representative again for his testimony.
thank you.
Representative. Assist the chair with the pronunciation.
Comtos.
Representative Comtos.
Yes, thank you, Mr. Chair and members of the committee. I just want to say a few words about this bill and why I co-sponsored it. I have a constituent who works for the state. He drives in a vehicle all over, but he's also a police officer in our town and has training. He has applied several times to get an exception so that he can carry a firearm in the car, in his vehicle. And the department hasn't even followed its own rules. Now, when police officers were at risk around the country, he was very, very concerned. So I am hoping that you will look at this bill carefully and understand that it's not just about schools, as people are saying, it's about public government property and public people and their constitutional rights. I mean, this person was very concerned. Like I said, he works for the state, he drives in a vehicle daily, and he's also a police officer, of which is no secret. And even with all his training, he is not allowed to carry a firearm with him while he is employed by the state. Thank you and I will be happy to answer any questions.
Thank you, Representative, for your testimony. Seeing no hands raised, the representative is excused. Next witness is Dr. Leonard Korn. Representative Muse, Representative Burnt has left the hearing. Do you see Dr. Korn in attendance?
Here we go. I was just able to unmute. You can hear me now?
We can hear you, Dr. Korn.
Hi, thank you. Yes, I'm testifying in opposition to this bill. And as I've said before, I am Leonard Korn. I am a psychiatrist in Portsmouth. I am also representing the New Hampshire Medical Society and the New Hampshire Psychiatric Society. And I'm testifying in opposition to this bill. I realize that there are already preemption preventing school boards from providing for safety relative to guns. And I don't agree with that already, that we already have that, but I want to oppose this bill, which is just expanding the preemption. It ought to be necessary for communities as well as school boards, as well as municipalities to vote to make their communities safer regarding guns, knives, and other things that people may carry with them. It is interesting to me that, again, we have another piece of legislation that would attempt to promote violence rather than discourage violence. And I think we need greater safety rather than less safety in our communities. So please vote against this bill. Thank you very much.
Thank you, Dr. Korn, for your testimony. Representative True.
Thank you, Mr. Chair, and thank you for taking my question. The way I'm reading the bill, basically the only change in the RSA is it's adding penalties for violating the ordinance, the state RSA's. Are you against, is that what you're against, that you're against the addition of penalties?
Yes, I'm against the addition of penalties for communities trying to make themselves safer rather than less safe.
Thank you.
Thank you, thank you, thank you, Dr. Corn, for your testimony. Seeing no further hands raised, Dr. Corn, you are excused.
Thank you.
Dina Ramiro?
Can you hear me? Hello?
Yes, we can hear you.
Thank you. I will do my best to fit in the 2 minutes. I respectfully ask you to vote against HB 307. I have to say this morning, I'm starting to feel very frustrated. Everything that I'm hearing is about the right to bear arms, as if this were the end all and be all of how we live in New Hampshire. Owning a gun is not the only way for citizens to protect themselves. Sensible gun legislations are also our self-defense. I'm frustrated that the gun lobby has shown no interest or willingness to sit down with those who oppose expanding these laws and to really find common ground to look at the fact that gun violence is a public health crisis in this country. It's very frustrating to me that all the testimony I hear this morning is about my rights and the danger that I might be in to exercise my rights. I'm just going to finish by saying that as a mother, a grandmother, and a retired school social worker, I say categorically that firearms have absolutely no place in a school. Educators and parents and school administrators have a duty of care to children and youth, and they cannot do that if people other than a uniformed police officer are coming onto the grounds with firearms. There have been too many school shootings already, and having someone with the firearm, as in Parkland, will show you it's not going to deter a shooting. Thank you for letting me testify. I have also sent you written testimony.
Thank you, Ms. Ramiro, for your testimony. Seeing no hands raised, the witness is excused. Chair now recognizes Robin
Skidlarek, can you hear me?
Yes, we can.
Okay, hi. Thank you, Mr. Chairman and House committee members. My name's Robin Skidlarek. I'm a resident of Londonderry, business owner, mother, and I'm also a volunteer with Moms Demand Action. I'm here to oppose HB 307, a dangerous and punitive bill that greatly weakens protections against gun violence and weakens our community's ability to enact and enforce ordinances that have proven effective in protecting its citizens. As it exists today, New Hampshire already bars by law from establishing and enforcing ordinances and regulations around firearms that they find reasonable, sorry, I have a sore throat, in the protection of their citizens. These ordinances and regulations can be tailored specifically to meet the needs of local communities in many states to provide life-saving tools to prevent gun violence. Unfortunately, our state's preemption law already prevents us from doing so. And now, instead of rolling back that preemption law and empowering localities to take steps to protect our communities, the General Court is pushing HB 307, a bill that would needlessly and dangerously expand the preemption law. This law would allow out-of-state gun lobby groups to bring lawsuits against New Hampshire cities and towns if they win, forcing courts to award damages of at least $100,000 plus attorney's fees. The bill would also prohibit localities from using insurance policies to cover these. I think Tracy Burkett mentioned this. It's not unreasonable that a town might want to do everything they can to keep someone with a loaded gun off of school grounds, high school grounds, elementary school. It's not unreasonable that Durham would like to take steps that they can keep firearms out of the hands of 18 and 19-year-olds dealing with pressures and influences that are part of a daily college life. I can't think of a worse thing than including guns into colleges. It's not unreasonable that local law enforcement be provided the added tools that they need to keep their citizens safe. And to those of you who are supportive of philosophy that it's important to give local communities more ability to govern themselves, this bill stands firmly in opposition to that guided principle. I mailed you guys my full testimony. I tried to make this short and sweet. I ask that you not move forward with HB 307.
Thank you very much for your testimony.
Thank you.
Seeing no hands raised, the witness is excused.
Thank you so much. Can't even talk.
What's the last name?
It's WELKAOWITZ.
Lauren?
Lawrence.
Oh, Lawrence? I do not. There's only two L's that I'm seeing. Let me check.
Cindy White then?
Cindy White?
Yes.
Yes, she's here. Want me to allow her talk?
Yes.
All right, thank you, Mr. Chair.
Yes, good afternoon, Mr. Chairman and members of the committee. Can you hear me?
Yes, we can.
Thank you. My name is Cindy White. I live in Hopkinton. I'm an attorney and a former senior assistant attorney general in New Hampshire, and I am adamantly opposed to HB 307. This bill is a transparent attempt to intimidate and to punish local public school officials who take seriously their obligation to protect students and teachers from gun violence. This bill is unconstitutional. It allows any citizen of the state who believes himself to be aggrieved, or any entity or organization whose membership is aggrieved, which, as the last witness mentioned, could even be an out-of-state organization, to file a lawsuit in the Superior Court of the county of the plaintiff's residence. It further provides that that citizen, entity, or organization, if they prevail in the case, would be entitled to receive damages, attorney's fees, and costs. The obvious problem with this is that believing oneself to be aggrieved, which is what the statute says, does not give a person or entity legal standing to sue in court. The dictionary defines aggrieved as having a feeling that one has been wronged. That is very different than having a definite and concrete personal injury, which is what is required by Part 2, Article 74 of the state constitution for standing to bring a lawsuit. The New Hampshire Supreme Court has made it clear that the legislature does not have the authority to grant standing to those who do not meet that constitutional standard. It's easy to see the ridiculous consequences that could flow from passage of this bill. A person who lives in Laconia could sue the Salem School District in the Laconia Superior Court if the Salem School District adopted a policy prohibiting guns in its schools. That person could bring a suit, and if he prevailed, would be entitled to $100,000 in damages without ever even having been to Salem or having been denied entrance into a Salem school while carrying a gun. Not only is it unconstitutional, this bill is bad policy. It's unduly harsh. It requires courts to order fines of $500 for an inadvertent violation. The sponsor said that it was only intentional violations, but it's not. If you read the language, it's $500 for an inadvertent violation. And it also requires.
We do have to limit testimony to 2 minutes per witness, and your time has expired. So what I would ask is if you could please conclude your testimony with a single sentence. Ms. White, you you've exceeded the time has expired. It's limited to 2 minutes, but you need to unmute yourself. The chair will allow you to conclude your testimony in a single sentence.
Oh, I'm sorry. Okay, I thought I was unmuted before. Okay, so it would be $100,000 of damage, even in the evidence of no harm, no evidence of harm. And holding attorneys, holding local officials liable for their personally financially liable for decisions they made in their official capacity would have a terrible chilling effect on people running for office. For these reasons, I would ask the committee to ITL this terrible bill.
Representative Newman.
Thank you, Mr. Chair. Can you hear me?
Yes.
Okay. And thank you for taking my questions. I may have missed it in 100 of emails we get. Have you submitted written testimony?
No, I haven't, but I'm going to. I have it all ready to submit.
Thank you very much. I'll be looking for that. Thank you, Mr. Chairman.
Thank you.
Seeing no hands raised, I want to thank the witness for her testimony. At this time, the Criminal Justice Public Safety Committee shall be in recess until 12:30 p.m. And for the members here, this is the time for your lunch break.
Lunchtime.
Do you actually think they're gonna do anything to him?
No, Republicans are too cheap.
Laura, put yourself on mute.
What one we opened first?
334, isn't it?
Yes.
Mr. Chairman, I do see Representative Panalakis does have her hand up. Oh, and she is unmuted.
Mr. Chairman? May I speak?
Yes, you can.
Were we supposed to have a hearing on House Bill 334 at 11:45?
That's true. But we're still on 307, I understand.
No,
Oh, if you close 307. Stop asking questions.
307 is closed?
No, we can.
I assumed we were closed on 307.
Tell you the truth, Representative, I was having my lunch and I don't know what happened.
I didn't hear the bill close.
No, Mr. Chairman, we're in recess on 307 and we still have 7 or 8 people with their hand raised to speak.
All right, we will continue with 307.
Okay, thank you.
Thank you.
I have another question before we go into 307. I believe that 334 should be in Fish and Game instead of before us because we do not regulate the OHVRs.
Well, you know, this is an unusual session. I don't know what to tell
Tell
you.
me about it.
All right. Lieutenant Burt?
Yes, Mr. Chairman, thank you. I would like to call, Mr. Chairman, if you don't mind, Penny Dean to speak for 2 minutes, 307.
Penny Dean?
Yes, Chair and members of the committee, thank you for having me. And I want to say, first of all, that I think this bill should be retained. I strongly support the bill. However, it needs to be retained, and I've thought about these terms and I do not say them lightly. This is probably the worst piece of drafting I've ever seen in the 20 plus years I've been to the State House. It is not crystal clear. It's not even cloudy. It's not visible from 10 inches. And I think this bill is actually dangerous and reckless. And again, I support the concept. I support RSA 5926 as strongly as I can. But what this bill does is repeal and reenact the current RSA 15926. And it does not have a savings clause. And I believe that's huge. Without a savings clause, I believe a court is going to strike down this bill. This bill is so poorly done that you would not even give it to a first-year law student to identify issues because it'd be like shooting fish in a barrel. And I want to start out with some of the basic problems with, or one of the many basic problems with the bill. First of all, I heard the sponsor say that it does not deal with private property. Well, it absolutely does. It talks about private organizations. If you look at the bill, and let me count how many times I see private organizations or private entity. We have page 2, line 11, page 2, line 28, page 2, line 31, 33, and 36, page 3, lines 10 and 15, page 4, line 1. That's just one of the many, many problems. The other huge problem I see is I could cite cases after case from the New Hampshire Supreme Court where they say the legislature is presumed to say what it means and mean what it says, and they're going to give effect to every word. And when you talk about the legislative intent, for example, they talk about declaring all ordinances and regulations null and void. But in other parts of the bill, they talk about measures, directive, rules, enactments, orders, or policies. It's not consistent in usage throughout the bill. When they talk about legislative intent, which is part of the bill reenacted, they talk about firearms, ammunition, components, but again, no policies. They use the term components and supplies. What is the difference between firearm and components and supplies? And my point to you is that you need consistent language in this bill. Of more important to me, when they talk about the penalties and prohibitions in what they have enacted or suggested as 15928, they specifically don't talk about.
Penny?
Oh, I apologize.
Yeah, Mr. Chairman speaking, if you can.
Oh, I apologize.
Yeah, you had 2 minutes, and I think you exceeded it by quite a bit.
Oh, I apologize, sir. I didn't see.
You can sum up your testimony and.
Yes, yes, sir. And I apologize for overspeaking. The gist of it is I think this bill should be retained. I think it's desperately needed. I think it's an excellent idea, but I think this bill could do much, much, much more harm and put us in a worse position than we are now if it enacted because of the horrible, horrible, inconsistent drafting. And I'm happy to take any questions.
Thank you. Questions by the committee? Seeing none, thank you very much for your testimony.
Mr. Chair, there's Mike Thornton. I would like to allow him to talk here.
Thank you, Chair. Thank you, committee members. Thank you, citizens. Mike Thornton, Milford, New Hampshire, as an individual. I support strongly the concept of this HB 307. It does not reopen preemption. Preemption exists. It does not authorize New Hampshire Constitution 2A. It exists. It merely allows a citizen to redress knowingly infringing those already existing rights and RSAs by any area in the lower government who chooses. It would create a minefield for a lawfully armed citizen. So what we're asking is realize that a lawfully armed citizen desires safety even more than any other person. And it's part of the reason we are lawfully armed, to protect ourselves and others. That's it. Thank you very much. I will entertain questions.
Thank you for your testimony. Seeing no hands raised, the witness is excused. At this time, the chair recognizes Amy. Sislak? I'm sorry if I'm pronouncing that correctly. And I just want to remind, your testimony is limited to 2 minutes. This time the chair recognizes J.R. Bull. And I want to remind the witness that your testimony is limited to 2 minutes. More technical difficulties. This time the chair will recognize Alan Rice. Just a reminder, your testimony is limited to 2 minutes.
Yes, good afternoon, Mr. Chairman, members of the committee. Thank you. I had sent written testimony in. I represent Gun Owners of America, a national organization with 2 million members and supporters. We strongly support House Bill 307. I wanted to take my 2 minutes to point out the inconsistencies in the testimony of some of the opponents of House Bill 307. They really believe that a rule and a sign will stop a murderer, criminal, or other dangerous individual from carrying a gun into a school, a town office, an arena, or any place else and prevent violence. It's not going to prevent violence. What will prevent violence is armed, law-abiding people able to fight back. When we see these violent attacks across the country, they occur in gun-free zones. New Hampshire doesn't have very many gun-free zones, and many of them are illegal. This bill would get rid of the illegal gun-free zones because it would include an enforcement mechanism to RSA 159-26, which is what's currently lacking. The opponents even acknowledged that they can't ban guns in these public spaces, but they're getting away with it because the current law has no enforcement mechanism. And I would urge the committee to vote House Bill 307 ought to pass. I thank you.
Thank you, Mr. Rice, for your testimony. Seeing no hands raised, the witness is excused. Zandra Rice Hawkins, you're recognized by the chair. Just a reminder, your testimony is limited to 2 minutes.
Thank you. As you all know, I'm the director of Gun Sense New Hampshire Project to Grant State Progress. We oppose House Bill 307. New Hampshire already has a preemption law, as has been stated. It already broadly prohibits local municipalities and school districts from enacting common sense firearms regulations. This bill takes that a step further and intimidates local officials from doing anything regarding the presence of firearms in high traffic public spaces or learning environments. This ridiculous bill could target staff or administrators who, for example, question someone bringing a loaded firearm or a knife into an elementary school. This bill would add new punitive measures to intimidate, punish, and bankrupt local communities and school districts, those court damages up to $100,000, and make the enactment or enforcement of local gun laws grounds for termination of public employees or removal from public office by the governor. I have to point out the incredible double standard here. This bill seeks to have the governor unilaterally remove an elected official from office for trying to protect their community from gun violence. But at the same time, the New Hampshire House and Governor Chris Sununu refuse to do anything about state legislators and party leaders who share racist, anti-Semitic, and sexist messages that encourage violence. We urge the committee to vote this bill down and instead spend your time on the real issues facing our state. Thank you.
Thank you, Ms. Hawkins, for your testimony. Seeing no hands raised, the witness is excused. At this time, the chair recognizes Cordell Johnston. And just a reminder, Mr. Johnston, your testimony is limited to 2 minutes.
Thank you, Mr. Chairman. Cordell Johnston, representing the New Hampshire Municipal Association. And we very much oppose this bill. It really is a pretty disturbing bill. 2 points. First of all, towns are already preempted from any kind of gun regulation, as several people have stated. The current law is very comprehensive, and there's no need for any new legislation. But local governing bodies do have the authority to control the use of town property. That is a pretty basic and obvious proposition. This bill would override that. It says there can be no regulation of the use of firearms on town property. Not talking here about possession, talking about the use of firearms on town property. Under this bill, people would have an absolute right, for example, to set up a shooting range on a town-owned athletic field, in a town cemetery, in a town forest, or anywhere else. It even says that a private entity that leases town-owned property cannot regulate the use of firearms. So if a town owns some fields that it leases to a local farmer, which is a fairly common practice in New Hampshire, the farmer could not restrict the use of guns on that property. The second point I want to mention is the way this bill treats local officials by subjecting them to fines and damages of up to $100,000, plus attorney fees if they make an innocent mistake. Selectmen and city councilors and aldermen are just average people. Every one of them is a volunteer trying to do something for their town, and they're not legal experts. Occasionally, they adopt an ordinance or a regulation that turns out to be invalid. That's called a mistake. And when it happens, it is very quickly corrected by the town attorney, or in some cases by a court. That is the enforcement mechanism. Not helpful to have the state legislature threaten.
Thank you, Mr. Joseph, for your testimony. You have reached, your time has expired. Seeing no hands raised, I want to thank the witness for his testimony. What's the other?
You didn't let him wrap up. 1 minute. 1 question, 1 comment, 1 sentence.
Mr.
We have to be consistent.
Is,
You want Cordell back up, Mr. Chair?
we have people. Who
Okay.
There's another phone number. I can't read the full number. The number ends in 359.
That was a previous caller. I can't recall who it was, but they did identify themselves when they came on.
And is what the phone number is 0000.
That's a former Representative Holt.
Representative Poole, you are recognized. Please be advised that your testimony must be limited to 2 minutes.
Hello?
Yes.
Chairman Addis, hi. Representative Hull, or former Representative Hull, speaking on behalf of myself as well as the New Hampshire Firearms Coalition. The bill before you is an extension of the policy that was passed in 2011 and signed by Governor Lynch at the time. This is an important measure. We as citizens expect our elected officials to follow the law. As was noted in the bill's findings, we are a nation of laws, and every person is subject to those laws, including those that are elected officials. Whereas those in Concord expect that citizens obey every law, speeding laws, other laws, it would be a double standard to allow elected officials not to violate state law and not be punished. We are asking that you extend the current law to make sure everybody's held to the same standard when it comes to complying with the laws that are passed in Concord. And this bill does just that. It puts a penalty for those who knowingly violate state law. I would ask that you would support this bill. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. If I could just speak to my two technical assistants. There's several people, members of the public that are still in, this as a panel member, just for make it easy to follow, can you remove those members?
Yes.
Mr. Singh, you are recognized by the chair to speak. Please remember that your testimony must be limited to 2 minutes.
Hi, can you hear me?
Yes, we can hear you just fine.
Okay, my name is Ajit Singh. I'm an ER physician. Thank you for letting me speak. I am in opposition to House Bill 307. I'm going to briefly read what I already sent in as written testimony, if you don't mind. It seems to me that the goal of legislation is to improve the health, welfare, and safety of the constituency it covers. I believe that House Bill 307 is the antithesis of this. Advocates for guns on campus push the undocumented belief that empowering armed civilians would help them defend themselves and others from mortal danger. There have been no documented cases of carrier intervention anywhere on campuses in this country. There have been no discernible deterrent effects by campus carriers. What there has been is an increase in self-inflicted suicide by gun on campus carry schools. This makes sense. The more guns and the ready availability, the higher the suicide rate. Firearms on campus negatively impact teaching, as instructors have been compelled to change their practices to avoid sensitive or controversial topics, so as to not inflame the sensibilities of prone students. And neurobiologists and educators all agree that young minds are still developing and prone to impulsivity when up till the early 20s or through their 20s. I would like to say, do we really want to convert our schools and colleges into armed zones where a bad day for a student or staff member who's carrying a gun could really become a bad day for others? The majority of current campus carry schools throughout the country have not supported legislation that was ultimately imposed upon them permitting firearms on campus. Now, I've put my hands into the thorax of people who have shot themselves. I don't know how many of you have done that. I've also helped talk to parents when their child was killed. I don't know how many of you have done that. It kind of bothers me that I see so many advocates talking about their love of cold metal above the love of warm blood.
Mr. Singh, I want to thank you for your testimony. Your 2 minutes has expired. Seeing no hands raised, the witness is excused. The chair recognizes Joseph Mullen.
Good afternoon, Mr. Chairman and honorable members of the committee. My name is Joe Mullen, and I'm from Grafton, Massachusetts. I'm the Northeastern States Assistant Manager for the Congressional Sportsmen's Foundation, the 501c3 nonprofit I represent today. I'm addressing you to express my support for House Bill 307. I will be submitting written testimony as well, so out of respect for your time, I will keep my testimony short. Broadly speaking, state preemption for firearms, ammunition, and knives further serves to protect law-abiding citizens from the risk of offending differing rules as they travel through varying locations. Arguably, the most important principle of preemption is the equal distribution of the law. I'm supportive of House Bill 307 as it serves to further deter discrepancies from locality to locality, ensuring that all gun and knife owners within New Hampshire have these equal rights. Once again, I'd like to reiterate my support for House Bill 307, and I will get my written testimony to the committee following this meeting. I'd like to thank you for your time.
Thank you, Mr. Mullen, for your testimony. Seeing no hands raised, the witness is excused. Representative Burke, is the 359 number, did we just call that?
We have tried to call that up, Mr. Chairman, and nobody, he must have had difficulties. We'll try it again if you'd like.
We'll try one more time. If your phone number ends in 359, the chair has recognized you to speak. If you wish to speak.
Good afternoon, Mr. Chairman and members of the committee.
My name is Jay Simpkin, resident of Nashua, New Hampshire. I'm a federally licensed firearms dealer and an international economic consultant. Want to address some points that have been made but need rebuttal. First, there seems to be an implicit assumption that more guns equals more violence and more death. Not so. In 1980, there were approximately 150 million firearms in the U.S., excluding military items. At end 2018, there were 423 million firearms. U.S. Department of Justice, Firearms Commerce in the United States, issues of 2000 and 2019. In that time, the homicide rate went from 10.2 per 100,000 to 5.0. Source, FBI, uniform, crime in the United States for each of those years. So the idea that more guns equals more death and more violence, not so. Second, in New Hampshire, as I pointed out on a previous bill, the state has been, since 2001 at least, the third safest, and in 2019, the second safest state in the union. So the idea that more guns in New Hampshire means more violence, not so. Source, FBI, crime in the United States for each of those years, usually table 4. Next, the bill as drafted does have many language defects, as an attorney pointed out. Those should be fixed. Next point, there is in the United States, sadly, a trend towards public officials, elected and appointed, bringing into their offices their personal agendas. Thus, they wish to abuse their public office to carry out things that may be desirable or not.
I want to thank the member of the public for their testimony. Your 2 minutes has expired. Seeing no questions, the witness is excused. The chair recognizes Daniel Itza.
Thank you, Mr. Chairman, members of the committee, for the opportunity to testify before you. For the record, I am Daniel Itza, residing in Manchester, New Hampshire, former representative. I'd like to snap you back to what the issue truly at hand. While firearms are the vehicle, the issue is really the legislature enforcing the Constitution upon the cities and towns. Part 1, Article 12, last sentence, nor are the inhabitants of this state controllable by any other laws than those to which they or their representative have given their consent. Part 2, Article 2, the supreme legislative power within this state shall be vested in the Senate and House of Representatives. It is about you ensuring that the towns, counties, and school districts do not act under the color of law. Now, I've recognized that there are problems with the way that this bill has been crafted. However, you also have at hand RSA 643:1, official oppression. You could link such violations to that law, and that would actually limit the financial liability of the bad actors because they'd be limited to $2,500, the penalty for a misdemeanor. I would advise you to go forward with this effort and ensure that the cities and towns, counties do not violate the Constitution by acting under the color of law. I'd be happy to take any questions.
Thank you for your testimony. Seeing no hands raised, the witness is excused. The chair recognizes Lauren LePage. Just a reminder, your testimony is limited to 2 minutes.
Good afternoon. Can everyone hear me?
Yes, we can.
Okay, my name is Lauren LePage. I'm the New Hampshire State Director for the National Rifle Association. We are in strong support of House Bill 307. It's one of our top priorities this session. State firearms preemption was enacted by the New Hampshire General Court to avoid a confusing patchwork of firearm laws across the state. Over recent years, numerous local governments have attempted to enact gun control ordinances in violation of this law. The potential for a myriad of local firearm laws makes compliance very difficult and nearly impossible for law-abiding gun owners. This creates a situation where gun owners and sportsmen have difficulty even knowing about certain laws, much less understanding where they apply within the city limits. I would just point out that New Hampshire has 234 established municipalities, and it's incredibly difficult to imagine a workable system if we had 234 different sets of firearm laws across the state. And I'm happy to take any questions.
Representative Burt, you're recognized for a question.
Thank you, Mr. Chairman, and thank you for your testimony. I know for a fact that other states have these types of laws. I don't know if you could point out one or two of the states that have this and how things haven't gone to heck, and how everybody survived, and it's better for the people of those states. So I think New Hampshire should have this.
Happy to. Indiana is one state where we supported a preemption bill in that state. It's just important to note this isn't expanding preemption. I mean, preemption is the state law. This is setting up an enforcement mechanism for it so that these violations are addressed. I'd be happy to provide a list to the committee of the states that have similar laws and sort of the impacts of those laws, if that's helpful.
Thank you, Mr. Chairman.
Seeing no further hands raised, the witness is excused. Are there any members of the public that are in attendance that wish to testify that haven't testified already? Please raise your hand. Seeing no hands raised at this time, the chair will adjourn the public hearing on House Bill 307.
On House Bill 307, we had 50 people sign in support of the bill, 256 sign in against the bill, and we had one person who signed in as neutral.
Thank you, Representative Muse. At this time, the chair will open the public hearing on House Bill 334. And just to state to the general public, for the purposes of this bill, this public hearing, public testimony will be limited to 1 minute per witness, with the exception of the member introducing the bill.
Thank you, Mr. Chairman and fine committee members. I am Representative John Burt, and I represent.
Representative Burt, you want to take the witness seat?
Oh, I can. It's easier, probably more, they can hear me. And I just won't ask questions, which I know is a rule, it's up to you.
I'm not 100% of the rule. If you just don't mind taking the choose to keep it.
All right.
Other members of the meeting, when they testified in person, are taking the hot seat will follow. I wouldn't want Representative Connolly, who's taking the hot seat.
Representative Burt, you should take the microphone with you. Save yourself.
Thank you, Mr. Chairman and fine representatives. I am Representative John Burt. I represent Goffstown, Ware, and Deeren, District 39. Mr. Chairman, I'm introducing this bill because it is basically, it's a real easy bill. It's housekeeping. So I can't imagine, much opposition on this bill because currently we have constitutional carry. Now, there is a fish and game law, I believe it's 215-A:20, that forbids anybody on a four-wheeler or snowmobile from carrying a loaded pistol. With constitutional carry, the New Hampshire AG's already instructed the Fish and Game that if they arrest anybody on this, it's going to be thrown out because constitutional carry will supersede this law. So this is basically just a cleanup. They want to, get rid of this off the books, and that's all this is. It just puts us in line for constitutional carry, which we have in its current law. Thank you, Mr. Chairman.
Representative True.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. If that's the correct Fish and Game law, 215A20, is that a Fish and Game ruling? Is that an RSA?
That's an actual RSA that Fish and Game has. Thank you for the question.
Representative Wallace.
Thank you, Mr. Chairman. Thank you for recognizing. I see pistols mentioned in this bill, but no mention of long arms. I mean, does firearm cover long arms?
I believe it was Senate Bill 500 2 terms ago. Senator Avard put in, and it passed. It is current law. That took care of the rifles and long guns in that section. This bill, this is my second time with this bill because the Senate 2 terms ago said that it took care of this particular law. So that's why they didn't pass it through, and they have since seen, oops, that is not correct. So the law is still there. Senate Bill 500 did not remove this like they thought it would. Yeah, so that's why rifles and long guns are not included in here. It's only pistols.
Seeing no hands raised, I want to thank the representative for his testimony.
Thank you, Mr. Chairman.
Representative Berg, you may still assist the committee with your technical support.
Yes.
You're not off the hook.
Yes.
At this time, the chair recognizes Penny Dean.
Can we find her? Yep, right there.
Sorry, the unmute button didn't come on the screen for me right away. Yes, sir. I would just say that I'm in strong support of passing the bill as written. It is very simple, and it does, quite frankly, keep a lot of police officers and prosecutors from wasting their time. Because what happens is they arrest someone, they charge them, they determine they can't prosecute them. They've made the person spend a lot of money and go through a lot of grief. And this is going to allow what should be and what's meant to be clear so that we don't have state officials, county officials all wasting our time and our money and taxpayer dollars. And happy to answer any questions. And I'm sorry, I'm from Concord, New Hampshire. I didn't say that.
Thank you. Seeing no hands raised, I want to thank the witness for her testimony.
Thank you.
At this time, the chair recognizes Representative Erica Leon, sorry.
Mr. Chairman, I'm not seeing that name, Erica.
At this time, the chair will recognize Dr. Joe Hannon.
Good afternoon, members of the committee. Thank you for listening to me again today. My name is Joe Hannon, Vice President for Gun Owners of New Hampshire. We are in strong support of HB 334. Like the sponsoring representative said, this bill is pretty much a housekeeping bill in a sense. We already had the section changed in law to allow permitless carry. The current statute, section 215A20, says no person shall carry a loaded firearm, but the exception is if there is a permit issued under RSA 159. Well, 159 section Roman numeral 3 pretty much says that the availability of a license to carry a loaded pistol or revolver under this section or under any other provision of law shall not be construed to impose a prohibition on the unlicensed transport or carry of a firearm in a vehicle on or about one's person, whether openly concealed, loaded or unloaded, et cetera, et cetera. So, this bill is just keeping in line with other.
I want to thank Dr. Hannon for his testimony, but the 1 minute limitation has expired. Seeing no hands raised, the witness is excused. At this time, the chair is recognizing Lauren LePage.
Good afternoon. Lauren LePage on behalf of the National Rifle Association, again, State Director for New Hampshire. In an effort to conserve time for the committee, our support for the bill, we sent in written testimony. We're strongly supportive of House Bill 334. It is just a cleanup bill, and I will just kind of defer to my written testimony to save you all from having to repeat what's already been said.
Thank you, Ms. LePage. Seeing no hands raised, the witness is excused. The chair recognizes Alan Rice.
Good afternoon. Thank you, Mr. Chairman, members of the committee. Once again, Alan Rice, a resident of Bedford, New Hampshire State Director of Gun Owners of America. We strongly support House Bill 334, and I want to emphasize that this is probably the simplest, most least controversial bill you're going to deal with probably maybe in the whole 2-year term. People can carry loaded guns concealed in public, in their cars, in their pickup trucks, on their boats. But if they want to carry it on their snow machine, they need a license. Very inconsistent with the rest of the laws. And I would urge the committee to vote ought to pass on House Bill 334 without any amendments or changes. And I thank you.
Thank you, Mr. Rice, for your testimony. Seeing no hands raised, the witness is excused. At this time, the chair recognizes Michael Thornton.
Thank you, Chair, committee members, citizens. Mike Thornton, Milford citizen. I support this strongly, speaking for myself. The laws of New Hampshire and the United States are complex enough without them conflicting with themselves. Please support and pass this bill. Thank you.
Seeing no hands raised, I want to thank the witness for his testimony. Are there any members of the public who wish to testify that are in attendance that have not testified already? Seeing no hands raised, at this time, the chair will close the public hearing on House Bill 334. Representative Muse, you are being recognized by the chair to read the support and opposed numbers to the public. You're muted. There you
go. On House Bill 334, there were 53 people who signed in support and 92 who signed in opposition.
Thank you, Representative Muse. At this time, the chair will open the executive session on House Bill 334. The chair will recognize Representative Burke for a motion.
Thank you, Mr. Chairman. The motion is off to pass, and I would like to make that motion.
I'll second.
The chair recognizes Madam Clerk.
I would like to make a motion to second that, please.
Thank you, Madam Clerk. That motion of ought to pass has now been seconded. Representative Burke, do you wish to speak to your motion of ought to pass?
Thank you, Mr. Chairman. Just very briefly, Again, this is just a housekeeping bill. They thought Senate Bill 500 was going to take care of that 2 terms ago, and it didn't. So the AG has, said that, we need to clean up some language here. So it's just basically a housekeeping bill, and I hope that everybody will support it because it's a good bill.
Chairman, I'll open the question up for discussion. Representative Hughes, you're recognized.
Thank you, Mr. Chairman. I just wanted to make sure that we note who didn't testify today. So there was nobody here from Fish and Game. And I think in previous hearings on similar bills, we have heard from folks in Fish and Game. One of the things that we didn't necessarily hear is why we had a law like this on the books in the first place. And my guess is that we had a law like this on the books in the first place because there's a better chance on things like snowmobiles and ATVs of weapons being discharged accidentally and potentially not only harming the person who's driving the ATV or the snowmobile, but potentially other people in the area as well. And I believe hunting from ATVs and snowmobiles, I think, was another issue that was brought up in the past. So I just wanted to make sure that everyone understands that there actually are some issues worth debating here, and it's not just purely a housekeeping bill. Thank you.
I have a question. Chair.
Representative Gathright, you're recognized.
This question is to you. Are you planning on executing anything else today, you think? Because in our conversation, you were very explicit in saying that we were not executing anything.
It's unlikely that we're going to have time to exec anything. We have a 1:30. We have a public hearing at 1:30 that we're hoping to get to. We also have to we have to adjourn today by 4 p.m. due to maintenance. So we have 3 more bills scheduled. Given the length of time, I can imagine the other House bills we heard today. I highly doubt that it would be appropriate to open those executive sessions knowing we might not be able to conclude them.
Thank you.
Representative Marson?
Thank you, Mr. Chairman. I only wish to comment on this bill in the sense that is no law that says you have to take your gun with you on your snowmobile machine. If you feel you might end up shooting yourself in the leg, leave your gun at home.
Representative Delakis, is your hand raised?
Yes, I did. I just would like to say that I will be voting against this because this bill belonged in Fish and Game because they are the ones that control the snowmobiles and off-riders. Thank you.
Representative Wallace?
Thank you, Mr. Chairman. Just like to make the point that Fish and Game is well aware of this bill. For those of you who have served on this committee for more than one term, we all know that if Fish and Game had a position one way or the other, they would have a representative here or online, and they don't, and I think that speaks volumes. And additionally, this bill is about firearms, not OHRVs, so it's absolutely in the proper committee. Thank you.
Representative Hopper?
Thank you, Mr. Chairman. Having served on the Fish and Game Committee for quite a few years, I know there's a lot of legislation restricting firearms in vehicles, and a lot of that stemmed back to the early 1900s when people would just drive down the road in their car and shoot deer on the side of the road. So I presume it has something to do with that type of behavior that is long gone. I don't think this will have, I think it's a great bill. Thank you.
Representative Hopper, if the chair may ask a question. So my understanding is it would still remain illegal to ride on a snowmobile and discharge a firearm for hunting purposes. That would still remain a crime?
Yeah, yes. Still illegal to be on a motorized vehicle. I think that's under federal law, That might just be ducks, I'm not sure, but I don't know of any law that allows somebody to be on a motorized vehicle and shoot at animals. What? Not New Hampshire.
Members, Representative Wallace, do you wish to add to the discussion?
Yes, Mr. Chairman. The only lawful motorized vehicle you can discharge a firearm from is a helicopter or an airplane for the purposes of hog hunting, which we don't do too much here in New Hampshire.
Information the chair was not aware of. Seeing no hands raised, the matter will now be put to question. The motion is ought to pass. The clerk will call the roll. If you are in support of the motion of ought to pass, please say yay. If you are opposed, please say nay.
Vice Chairman Welch,
Yes.
Representative Burt,
Yes.
Representative Hopper,
Can I say maybe?
Representative Hopper, please
Yes,
say yay or
yes,
nay.
yes.
Thank you.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testerman,
Yes.
Representative True,
Yes.
Representative Pratt,
Yes.
Representative Marston.
Yes.
The clerk votes yes. Representative Harriet Gathright,
No.
Representative Pantelakis,
No.
Representative O'Hearn,
No.
Representative Bourdonnais,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Bolden,
No.
Representative Conley,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
Chairman Abbas.
The chair votes yes.
Mr. Chairman, the vote is 11-10 yay.
By a vote of 11 yeas and 10 nays, the motion of ought to pass was passed. Representative Burke, will you be preparing a majority report?
Yes, Mr. Chairman.
Will there be a minority report?
Anybody want it?
Representative Conley, every time I ask that, everyone always looks in your direction. Even the people on the computer screen.
Mr. Chairman, I do not intend to write a minority report.
I'm sticking up for you. I think we redistribute the wealth.
I appreciate it. Thank you, sir.
Somebody will, I'll let you know.
Before the end of the day, just someone who voted nay, just please let the chair know whether you be, someone's preparing a minority report. This time that.
No consent calendar then?
No consent calendar. At this time, we'll close the executive session on House Bill 334. The Criminal Justice Public Safety Committee will be in recess till 1:45. Please, 11:10.
Thank you.
Oh,
live.
It's not about the merits of the argument at this point.
At this time, the Criminal Justice Public Safety Committee, the chair will open the public hearing on House Bill 620.
That's a shame because there's real, I think it's important.
Representative the hand raised?
Yes, I had a question of the chair. Will we be having executive sessions after this bill?
Going forward for this country.
That's a good question. There are 2 other bills scheduled thereafter. If there's time, I will say that for the bills this morning, I would highly doubt that we would have the executive session on any of those bills. Because I believe the executive session would be much longer and the discussion may take a while. I think with the other bills that's scheduled this afternoon, we might be able to exec some of these bills depending on how the hearings go.
Second question, I only have one bill listed in the calendar. Did you say there was 2 others?
Yes, the original notice omitted 2 of the bills. The other 2 bills are House Bill 579, and that is scheduled for.
Hey, thank you.
House Bill 338 is scheduled at 3:30. We do have a stop right at 4 o'clock. So I will tell you that House Bill 579, the sponsored bill is not going to be able to attend. So we wouldn't be executing that. We're going to give the sponsor a opportunity to speak on the bill.
Thank you.
Your conduct was intentional.
This is 4 bills, 4 institute indicated. Leave the rest of us, the executive session, everything else. Give us more time to do that. If we get home early, we can actually eat lunch. I'm getting tired of having my supper at 9 o'clock at night.
The good news is we have to stop at 4, so it doesn't matter what I want to do. Yay! I don't have a list for 620.
No, I don't even have the bill. I thought I did.
Representative Bolden, you are a sponsor of the, I see Representative Jackie Sheridan.
Yeah.
The chair recognizes you to speak.
I only had 2 people signed up to speak.
Can you see me okay? Can you see and hear me?
We can hear you and we can see your picture, not live video.
Okay, I apologize. I'm sorry, is there a way for me to add my video or?
Yes, Representative Burt, can you please assist the witness in activating the live feed?
I see no options, Mr. Chairman. I think it has to be on her side, which she would say it says stop or start video.
If I may just chime in, she would just need to be promoted to a panelist in order to start her video.
Correct. I just promoted her. Oh, there she is.
All right.
But she's muted. Let me unmute her.
Sorry.
We're still learning over here. You're recognized for your testimony.
Thank you very much, Mr. Chair, and thank you, members of the committee. So my name is Representative Jacqueline Cretion. I am one of 2 representatives of Hillsborough District 42 in Manchester, and I'm here today to give my testimony on HB 620, requiring law enforcement agencies to gather and analyze certain demographic information at police stops and searches. So I filed this bill in part in response to the Lee Act recommendations that came out last year, which Governor Sununu and many members of the state law enforcement community have stated that they support unequivocally. This item was also included in the Seacoast Black Lives Matter requests for reform. So my belief is that this topic has broad bipartisan support. So one of the Lee Act's action items for the legislature was to implement some requirements for police to collect information about the race and gender of any person who they were stopping or searching, regardless of the outcome of that stop or search. So currently, as I'm sure you know, this information is only available for stops or searches where further action is taken. And collecting data for all stops is important because right now we just don't have clear empirical information on who is being policed and at what rates. So my background, I'm a scientist, and that means I'm keenly aware of the issue of sampling bias. So if you're searching for your keys under the streetlight, that's where you're going to find them, right? So if we're spending 90% of our time looking for crime among certain communities, then that's where we're going to find it. So it's important to know whether our policing resources are being applied proportionately. We also don't know whether all demographics interactions with the police lead to similar outcomes at similar rates. Or if there's similar systematic differences in those rates. We do know that at least as of 2014, the last time I'm aware that this was looked at, Black and Hispanic people were arrested and incarcerated at higher rates in New Hampshire than whites, and at more disproportionate rates than are seen nationwide and in other states. Particularly, I think this issue is important for accountability. The New Hampshire Department of Safety and state police have an explicit impartial policing policy that prohibits stops or detentions based on race, etc. But there's no mechanism currently in place to report on how well this policy is being adhered to, which makes it difficult to know how well the understanding of this policy is implemented among law enforcement and whether we need additional resources or clarification on that. And further, I just wanted to mention, so the current bill does not require or even request reporting at the level of individual officers, but my hope is that the availability of this information internally might help law enforcement supervisors identify outliers who might benefit from help. There's also some evidence that even just the simple act of tracking this information might help individual officers notice, if there are unconscious patterns in their behavior, sort of like if you're tracking your internet usage, you realize how much time you're spending watching cat videos. Just collecting this information, I believe, can be a tool to empower officers as well as for external accountability. Just the last thing that I wanted to say, and sorry, I hope I'm not going over my 5 minutes, but I'm aware that there's work being done in the Senate on some of the Lee Act recommendations. I absolutely don't object to the contents of this bill being rolled into something larger. I just do want to emphasize the importance, I think, of collecting and reporting demographic information, just so we have a clear picture of how our police resources are being applied across different communities. So thank you for your time, and I look forward to taking your questions.
Representative Burt, you are recognized for a question.
Thank you, Mr. Chairman, and thank you, Representative, for your testimony today. You spoke that Governor Sununu supports legislation like this. Does he support this particular legislation? Is he approving of this?
I have not spoken with him directly. However, this language in this bill mimics the language in the Lee Act recommendations, so I presume so.
Representative Hopper.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. One of the key variable in whether or not somebody does or does not interact with law enforcement is family structure. Have you thought of adding that to your list of demographic information?
I had not considered that. No.
Thank you.
Representative Muse.
Yes, first of all, thank you for this legislation. The work of the Lee Act Commission was extremely important, and it's nice to see that that some of it is finally making its way to us. I do have a question about how the information is actually collected. So, where the rubber hits the road is when an officer actually has to put something down on paper. Today, we have a lot of people in New Hampshire and everywhere else in the country who are multiracial. So how does it work in the case of somebody who might be like our former president or has parents of different races? Does the officer guess? Is this information taken from somewhere else, or do they just ask the person?
So that's a really good question, and definitely I think a sticky point in this bill and similar legislation. One suggestion that I've heard is if there's information on, for example, a driver's license about racial identification, that could be used. Currently, I know we don't have that in New Hampshire. I think to get to the heart of this bill, I think probably the officer's perception is really what's most important. So I would suggest that perhaps that is what could be used, but I did deliberately omit that specific from this so that the rulemaking bodies can get into that nitty-gritty themselves. I assume that, you know, the police officers who are out in the field might have a better idea of how they would like to handle that, how they would like to make that consistent. So I sort of leave that level of detail to them.
Thank you.
Representative Testerman?
Thank you, Mr. Chairman. Thank you for taking my question. Along with Representative Hopper's question about race and so on, how do you, it's a sensitive issue. Gender is also. How do I determine if I'm a policeman what gender the person is that is in front of me?
Thank you for that question. I think really similar answer. In this case, I think it is a little more clear since that information is listed on the person's ID. So I would go with that if it's available. Otherwise, best determination, or you could say not determinable. I don't think it needs to be, 100% perfect all the time. Not requesting chromosome spreads or anything.
Representative Gaffrey?
While it's not up to us to make that determination, I'm just wondering, what do you think about if the person is willing to give their ID or what they are, their gender or their race? What do you think about that?
Oh, sorry, for me. I think that would be fine. Yeah. Yeah, sorry.
Thank you.
Yeah.
Representative Marston?
Thank you, Mr. Chairman, and thank you for taking our question. If this bill were to pass, how and in what way can we be assured of the veracity of the report?
Well, oh, sorry. Go ahead.
Truthfulness of the report.
I mean, I think there's always going to be a level of trust, as there is in any sort of report that a police officer prepares. I do think one advantage of collecting this information broadly is that, you know, we'd be able to compare it across municipalities and things like that and see if there are outliers. So that might be a way to tell if perhaps something looks amiss in a particular area, or again, for supervisors to be able to look at that data, you know, just for themselves. But yes, public trust, you know, law enforcement takes an oath to be truthful on their reports.
Representative Hopper?
Thank you, Mr. Chair. Thank you, Representative, for taking my question. An obvious issue with this legislation is 28A. Who's going to pay for it?
So partly I'm taking the governor at his word that he believes every recommendation in the act should be implemented, that cost should not be an issue. He's on record saying that. I believe, officers collect a lot of data, a lot of paperwork already. Adding these 2 little items in one annual report hopefully is not an enormous burden. It seemed to me to be sensible to roll this into normal operating costs as opposed to, designating a specific revenue stream for a single report and a couple pieces of data. But I'm certainly open to other suggestions if you disagree.
Thank you.
Representative Pratt?
Hello there. Thank you for being here today. I got a question. Won't people feel prosecuted if they're asked to give this kind of information? I mean, a law officer that they may not even trust in the first place is asking them what they are. In the beginning of prejudice is putting a label on somebody. So.
Yeah, thank you for that question. I agree that that's for sure a concern. So going back to what Representative Muse had said about the specific mechanisms for how the information is collected, whether we're asking the person to give the information or just going by the officer's estimation or going by a record on an ID, if that's available, for sure is something to consider in the implementation. I didn't want to get into all that in the RSA, but yeah, does that answer your concern? Or?
Well, thank you.
Representative Gabbard, do you have a question?
Yeah, I did. Thank you, Mr. Chair. Thank you for taking my question. On the bottom of here, it lists the agencies contacted. Were these agencies also a part of the LEAC committee? Do you know?
Somewhere, I'm sorry, I have to look. Yes, I believe all of them were. I guess I'm not 100% sure about the counties and the municipal association, but I believe that yes, all 4 of those agencies were part of the LEACT.
Thank you.
Seeing no further hands raised, the chair would thank the witness for her testimony.
Thank you very much.
Joseph Ebert, you're recognized by the chair to speak. For the purpose of this public hearing, testimony will be limited to 2 minutes.
Good afternoon, members of the committee. It's good to be back in front of you again today, if even virtually. My name is Joseph Ebert, E-B-E-R-T. I'm a captain with the state police. And I want to echo some of the very healthy discussion that was just had. But I want to start by saying the colonel of the state police, as well as the commissioner, wholly support the vision of the LEAC committee. So having said that, I think Representative Muse's point is one that's well taken and one that we have concern over, which is the determination of race. Somebody brought up the conversation of how that would go as to asking somebody their race. And in past hearings, I know it's been discussed that, especially once that individual is has been notified of whatever offense they're alleged to have committed, could that lead to that interaction being poor? And I suppose that's all in how it's presented. But more importantly, what I'm concerned about is if we rely on the officer's estimation, then the information may be inaccurate. And I guess I would be, or as an agency, we would be looking for the most accurate way. And I don't know what that is. I truly don't. But I wonder what other states are doing and how they've accomplished this statistical gathering. So the second issue that, again, was also discussed was the fiscal impact. I think more than anything, I would say, and again, this is something I know that has been discussed in other hearings, but I would say it here from my own experience, making changes to our existing contract for records management, even though it really does seem like a very small thing to make a change to collect different data. That's a significant change to a contract that has fiscal impacts. And I'm concerned about the 60 days from the passage of the bill that it would take to actually put those changes in place. I want to kind of conclude my statement by saying, I don't in any way want to come across, nor does the state police, as rebuffing this or trying to make this a difficult process when, or more difficult than it needs to be. I just want to make sure that.
Mr. Ebert, thank you for your testimony. The 2 minutes has expired. However, there is a question by member Representative Burt.
Thank you, Mr. Chairman, and thank you, officer, for your testimony. During the last speaker, we had one question that came up from a representative about, and it just made me think about this a lot. So I just want to, ever since you're out in the field, what your experience may be on this. There are some people that, you know, I'm not one of them, but for some reason, you know, they're scared to death of the police when they pull up behind them. And, you know, I guess I understand some of that. So what's going to happen if they start profiling? Because that's what almost this is doing is, you know, they're profiling the individual to see what race they are and other items that they have to list. How do you think that's going to interact with the officer and the person being pulled over?
So I think that it could present a difficult interaction. You know, I think ideally we would know, as was mentioned in the previous discussion, we would know the race of the individual by the document that they present to us. And I say that in an ideal sense because my understanding of that would be that that's how they're declaring. And how to determine that, the veracity of that, I guess, is another discussion. But ideally, we would know the race of the individual based on the document that they present us. And could it lead to you know, a further difficult interaction? Yes, I think it could. Hopefully, that's something that could be overcome as well.
Thank you. Thank you, Mr. Chairman.
The chair may inquire of the witness, and I want to thank you in advance for taking my question. When it comes to gathering the data and, I suppose, classifying different races, will it be consistent with classifications, for example, like that they use for the census?
Respectfully, sir, Chairman, I truly don't know. That may be a way to get at that information. I think that's one thing that, and maybe a creative way to figure out how to identify individuals without having the not confrontation, but without having the interaction that Representative Burt was referring to on the side of the road. So perhaps the census is a mechanism with which to garner that information. How that gets from the census to the information that officer would be dealing with, or that trooper would be dealing with roadside, that I'm not particularly sure of.
And just a follow-up question. And the concern that I have is not with the intention of the bill. I can use myself as an example. I've seen a lot in just my short time as a member of this body, seen several bills come before this committee, and some bills will classify me as one race and some will classify myself as another race. And I notice those inconsistencies, which can be very confusing for someone like myself, especially when asked, what is my race? So I'm just trying to figure out if you're going to gather the data, consistency. And I was just kind of using the census as an example of maybe it would be like whatever when they gather information, just for classification purposes. I'm just wondering if that's, or would it be more specific than that? For example, Caucasian is a classification. Within the Caucasian classification, is white is a race.
Yes. So I guess, sorry, that's not something I could 100% speak to because I'm not sure the categories which have been outlined to collect. What I can tell you though is your own experience is what I worry about. So I want the information that is provided to be accurate. And I don't think that the issue will be the veracity of the statement of the officer to say, this is the race of the person that I believe that I was looking at. I think where the possibility for error comes in is whether you identify somebody, and one population that I heard referred to previously, so I'll use that as an example, but somebody who is of Dominican descent, are they being identified as being Black, or are they being identified as being something other than that? And I think that that's a really difficult distinction for somebody to make on the side of the road. And again, this is not pushback from wanting to have what could be a difficult conversation. It's just wanting to make sure that there isn't error in the information that we are providing that's going to be so heavily relied upon and should be.
Thank you for taking my question. Representative Muse?
Yes, thank you for taking my question. I wonder if there isn't a way around this. I'm a little bit familiar with database projects and things of that nature. And adding one field sometimes is as easy as adding 20. So given the fact that virtually any of the ways that we're talking about collecting this data would be imperfect in some way, whether it's identification by the police officer, whether it's an ID card that may not have the particular classifications that we're looking for yet, whether it's information from the accused themselves that may or may not be true. The issue is it's hard to get to a point where we ever really know for sure. So one of the things that strikes me that we could potentially do with something like this is just add another field that indicates how the data was collected. So for instance, give the officer a chance to say, I got, it came from an identification, check. It came from the suspect, check. Or it came from me. And that way we would know, we would have the identification, and we would also have some idea of how the data was collected. And that additional data might actually be useful as well.
Representative, is there a question for the witness to answer?
I'm just curious if that would address the captain's concerns.
So Representative Muse, thank you so much for that. And I do think that is something that may help to address the concerns, not necessarily of just myself, but of the Division of State Police. The only thing I would reiterate, so I think that's a really ingenious way to kind of look at a couple of different data sets. The only concern that I would reiterate is that I would want Field A to be just as powerful as Field B. And my concern is that one would take precedence over the other. It should be, the method of identification should be, in my estimation, should be reviewed just as much as the identification itself, so that the two are handled hand in hand. And if that were in fact the way to move forward, perhaps that is, and that's far above my level, but perhaps that is a kind of an ingenious way to try and get around what seems to be the inherent issue.
Thank you.
Representative True.
Thank you, Mr. Chairman. Thank you for taking my question. Earlier you made reference to, and I didn't write it all down, but a cost to change the data collection contract or something like that. Do you have any idea what that cost would be?
I can't say what that cost would be, and I don't think that anybody could for the entire state of New Hampshire. What I can tell you is I am aware that there are a number of disparate records management systems throughout the state of New Hampshire. So lots of police departments use lots of different records management systems, and some police departments have no records management systems and rely upon Excel spreadsheets and things of that nature to keep their information. And while that may seem really outdated to us, that is a reality, I think, for some of our communities. So what I can say is there is a cost that is incurred with that, and it's not necessarily the changing of a field that is so difficult, but it is the changing of the contract that exists And what I can also speak to is the state of New Hampshire, under the Division of State Police, has been in an RMS purchasing process for almost 2 years now, looking at what fields to collect and how to collect them. So it's been a very extensive process, and I would imagine by the time we get to the end of that, sir, we're going to have a pretty ironclad contract that says this is what's expected of our provider. Going back to them and making changes to that is, like as in any contract, is going to have a fiscal impact. And I'm worried both for the state side, but also for the local municipalities, that impact may be overwhelming. And again, I can't speak to what it would be, because it would differ for every community throughout the state who had a different RMS system.
Thank you.
Representative Hopper?
Quick one. Thank you, officer, for taking my question. Do you know if local law enforcement already collects information every time they stop anybody? Or would this be an entirely new process?
So I truly can't speak to what each department does, especially at the local level. What I can offer you is anecdotal, and my hope is that there will be a speaker behind me who can offer much more evidence-based testimony. But what I can offer is that I've listened to other hearings where municipalities have said that they're not currently collecting this information, and to do so would cause a change in the process that they statistically analyze their information by. So I may just not be the right person to speak to the local police departments as a member of the state police, and I apologize for that.
Representative Conley?
Thank you, Mr. Chairman. Mr. Ebert, thank you for taking the question. It was really reassuring to hear at the beginning of your testimony that the state police supports the LEAC recommendations. One thing that we have seen is that these recommendations typically have a cost, and that cost is often cited as a justification not to do something. So I guess I'm wondering, do you have any concern, given the agency's support for LEAC, that cost could be a reason why none of this gets done, none of these recommendations take effect?
So thank you for the question, Representative. And I think if my testimony has come across as that a fiscal note is a reason not to do something, that's not at all what I intended. The purpose of bringing up the fiscal attachment is to try and generate a discussion as to where that funding would come from, where it would best come from, and also to discuss the 60-day timeline that's attached, because I do think regardless of where that funding comes from, that 60-day timeline is very restrictive. So it is not, in my estimation, as was previously said that the governor endorsed it, the finance should not be the reason that this does not go forward. But I do think it should be part of the discussion, especially when talking about a timeline.
Seeing no further questions, the chair would thank the witness for his testimony.
Thank you so much.
Chair recognizes Charles Reynolds.
Good afternoon. Can you hear me, Chairman Abbas?
Yes, we can hear you.
Okay. Good afternoon, Chairman Abbas and members of the committee. I'm Charles Reynolds, and I'm here on behalf of the New Hampshire Association of Chiefs of Police to register our opposition to House Bill 620. I'll be brief. The value and usefulness of accurate demographics is not in question, clearly not in question. However, we find this bill presents two major obstacles. First, in order for demographic data to be of value, it must be accurate. Therefore, absent the inclusion of the requested demographic data on an individual's driver's license, state-issued or other recognized identification, the recording of such data relies on an officer either one, asking for that information, which is clearly not a recommended practice, or two, recording his or her perception of the person's race, sex, or other demographic data. This clearly leaves officers open to criticism for either not accurately recording or, worse yet, manipulating the data. Therefore, no matter how careful an officer may be, the resulting analyses may be subject to challenge. Accordingly, absent a requirement that demographic data be included on official documents that may be requested by an officer, we cannot support that provision. Second, even if the data could be accurately recorded from the documents described above, the suggested analysis is another matter. Law enforcement agencies in New Hampshire, particularly the smaller ones, which comprise a majority of departments, do not have the analytical capacity to do so, nor are they likely to acquire the funds to purchase new or modify existing data systems to accommodate the analysis this legislation suggests. Accordingly, for practical, operational, and fiscal reasons, the New Hampshire Association of Chiefs of Police must oppose this legislation.
Excuse me, Mr. Reynolds, we have to limit testimony to 2 minutes. Do any members of Representative Testament?
Thank you. Thank you for taking my question. You touched on it, but the bill requires the police agencies to analyze the data. Being an engineer, you know, I have to have some bounds is what I would have to analyze. Do you have any idea what they're asking for here? Is he here?
I believe he's, well, you can unmute yourself.
Okay, I'm sorry. It appears that they're asking the individual agencies to do an analytical process and then provide that data to where it will be centralized. But that would require, as far as we can see, that each agency would have to do the analysis of each of those categories by demographics, which some agencies can do part of that. I'm not sure that any can do all of it, but my information from the chiefs that I've talked to in preparation for this testimony is that many can do a little bit of it, but there's no one we've been able to discover that can do all of the analysis that seems to be required.
Thank you.
Representative Knight.
Thank you, Chairman, and thank you for taking my question. So as I understand it, we currently don't gather this data just because we don't have the resources?
No. It's really a question of accuracy. When you get to demographics, and I think some of the others questions have been about how you gather the data, and specifically regarding race. Clearly, it's very offensive to folks, for officers to ask for that information, and for an officer to record their perception of the race is fraught with danger, because as has been pointed out, we have so many folks that are of mixed race, and the error can be high, and therefore the resulting analysis can be incorrect.
Representative Knight, you recognized for a follow-up question?
Thank you, Chair. So you don't see a problem not being able to tell us how many, let's say, people of color you pull over versus white people for the same offense?
Oh, I think it's pretty clear from the police perspective that we have no question whatsoever with providing that data. The question is, how do we obtain it in an accurate way? It should be obtained, but the fact is, right now, there's no way for police officers to accurately obtain that data. As I pointed out, the officer, as a practical matter, is not allowed to ask for it. And secondarily, his or her perception may be incorrect, which in the end result gives you an incorrect conclusion. So be clear, there's no objection to collecting and documenting the data, why people are stopped, what happens as a result of those stops. No question at all that that's important information. The question is there's no, presently, there's no way to accurately obtain that data. And the suggestion, of course, is that it be on the driver's license or some identification. Therefore, the person being stopped has self-identified.
Representative Hughes.
So if the only way is to get this information from something like a driver's license, one of the issues I think we all run into is our driver's licenses are renewed every 4 years. So if you take a look at the timeline, for something like that, we could conceivably be in a situation where it might take as long as 4 years before everybody has these fields on their license, meaning that the amount of usable, analyzable data that we have may not reach a critical mass for another 4 years. Do the chiefs think that that is acceptable given the current racial climate in the country and the state?
Well, it would be a trade-off between either waiting to get accurate information or rely on information that was highly suspect.
Representative Hughes, you're recognized for a follow-up question.
Sure. I'll save it for the executive session, Mr. Chair.
Representative Kessman, Representative Gaffer, do you want to have your hand raised? I saw you both waving.
I was trying to figure out how to word this as a question. I'll figure it out.
It takes me a while to catch on. It's no question.
Okay. Several states do collect demographic data. So I guess my question would, because in my opinion, would you, representing the chief of police for New Hampshire, be looking at data that other states are using, or how they're using, or how they're processing, getting that information? Or I guess a better question is, did any of you do that?
Do we look at other states, or was that the question? I can maybe address that a little bit from a personal perspective. One of the projects I worked on for up until a couple of years ago for 7 years involved exactly this, a collection of stop data. And one of my jobs was to analyze stop data, and the database that we looked at involved about somewhere between somewhere around 10 to 14,000 data sets. And we looked at this data on a monthly basis. And while it was very valuable, it wasn't based upon any self-identification. There was always an area that was suspect. And given the fact that the volume was so high, the volume was so high with, particularly with African Americans, that even if it was not entirely accurate, it gave us a pretty good picture. But when you get to New Hampshire, the database isn't going to be as large as that. on a monthly basis or even on an annual basis. So I think it's a little more important that the data be as accurate as we can make it. And I just want to make sure everyone understands that the New Hampshire police chiefs do not oppose the collection of demographics. It's a question of how do we get from the idea of collecting the demographics to making sure they're as accurate as we can possibly make them. And if we have to have an interim process until we can assure that data is included on driver's license or other identification, then maybe that's something that needs to be worked out. But ultimately, I think everyone would like to have that data be accurate because we're making assumptions on the basis of that data. And those assumptions are going to predict actions that may or may not be taken. We should do that on the basis of data that's as accurate as it possibly can be. So we're trying to get to accurate data in a way that's practical, and I think we all need to work together to get there.
Seeing no further questions, I want to thank the witness for his testimony. The next witness is Jim Demers.
Thank you, Mr. Chairman. For the record, my name is James Demers, and one of the clients I represent is the New Hampshire Police Association. I just wanted to make you aware, just for informational purposes, that Senate Bill 96 has had its hearing in the Senate. That is a bill that was actually drafted by the Attorney General's office to conform with many of the provisions that are in the LEAC report. And the demographic issues that you're hearing discussed today are in that bill. And I think if you are able to hold the bill you've got and wait for Senate Bill 96 to come over, you'll see that a lot of the issues, sort of the holes that people are raising that might be in this bill today, are addressed. And I'll give you a couple of examples. So that particular bill actually does have language that modifies the driver's license information in the state so that race and ethnicity can be collected on a driver's license, which is not today. That's certainly going to make it much more easier and, as Chief Reynolds said, more accurate in gathering that information. One of the questions that came up is there a 28A issue if the local communities are mandated to do the analysis of all this information? That particular bill in the Senate actually puts the responsibility on the Police Standards and Training Council to gather the information, analyze it, and actually post it on their website so that it's available for the public. So that particular bill, which is the actual LEAC legislation, is making its way through the Senate. I have pretty strong confidence that it's going to pass the Senate. So I think you're going to have a bill coming to you that's going to address a lot of the questions that have been raised today, and it might be best to wait for that bill to get to you.
Are there further questions from the committee? Seeing none, the witness is excused. Thank you for your testimony. Who do we have next?
Mr. Chairman, I see no hands raised.
Well, we will conclude the hearing on House Bill 620.
Chair, we have sign-ins on House Bill 620. There were 97 people who signed in support of the bill and 10 people who signed in opposition.
Thank you, Representative Hughes.
Thank you.
Boy, I'll tell you, the lawyers don't take care of their paperwork very well.
No, they do not, Mr. Chairman.
I'm finding that out.
I think we all agree with you in this room.
I don't.
You can open up,
Well, we're gonna open up House Bill 579.
And would you like me to open that, Mr. Chairman? The prime sponsor is unavailable.
Yes, Representative Burt will introduce the bill.
All right, thank you, Mr. Chairman. I am Representative John Burt, representing Goffstown, Ware, and Deering, District 39. I'm going to open up House Bill 579, requiring notice to the public before immigration checkpoints are conducted. Thank you, Mr. Chairman.
I just have a question. If we have the sponsors that are here, why wouldn't we allow them to open up?
Would you like me to answer that, Mr. Chairman?
Yes.
The prime sponsor asked us to, or asked the chair to retain the bill. I believe it was to retain it. He's out on medical issue, or a issue, I shouldn't say medical, a issue with a family member, a doctor's appointment or something like that. And that he wants to testify on this, but he just couldn't today. So, you know, as a courtesy to the prime sponsor, which we have done many, many times, both sides, you know, that's why we're going to hold it.
Okay. I guess the other question, now ask another question.
Yes, you may.
So the prime sponsor has a slew of sponsors that they got, and I'm just curious, was those sponsors made aware?
I do not know if they were.
Okay. Just curious.
Yeah.
Thank you.
Yeah.
Chair.
Oh, one answer, Representative.
California, Pennsylvania, California, Pennsylvania, and I gotta look at the other one.
Representative, that's right.
Oh, I'm sorry.
Well,
He just asked me a question.
One of the reasons they may not want to introduce the bill because they may want to raise some questions afterwards. They can't do that if they introduce the bill. That's
Okay.
just a possibility.
Thank you.
We have, who is it?
Mr. Chairman, you have our hand raised.
We have one.
No, one right in front of you. If you look to your right, Representative Marston.
Representative Marston has a question.
Thank you, Mr. Chairman. With what I've heard, is it a procedure that we can use that says we suspend this for the time being until the prime sponsor is available? Is
Well, we
that-
have someone, we have a couple of people who want to testify. We will take their testimony and then make that.
No problem, thank you.
John?
Yep. I apologize. I'm going to slaughter your name, so it's, let me just bring you on, and I do apologize. Is it ASMA is your first name?
Yes, can you hear me?
Yes, I apologize. I will butcher your name. I'm terrible with names.
That is okay. It's pronounced like the letter S and then ma, Esma.
Oh, thank you.
Yeah. Yeah, so my name is Esma, and I am with Rights and Democracy New Hampshire, and I am speaking today in strong support of HB 579. And I have personal experience with these checkpoints that Border Patrol conducts in our state. I have submitted an article I shared in the Concord Monitor about my experience with all of you via email as well. So let's be clear that these checkpoints are not nothing more basically than racial profiling of people driving in the state of New Hampshire, pulling out those who they judge to be from another country or have brown or black skin. I am a very visible Muslim woman who wears hijab and is indeed an immigrant, but I have citizenship. The only reason I was able, that I am able to be here today is because of a flimsy document that is the deciding factor of whether violence would have been enacted on me that day, a violence that would have physically removed me from my children and family. As I drove up, we were met with what looked like heavily armed military, but they were Border Patrol. They stopped our car and asked if I was a citizen. I refused to answer such an invasive question, and they pulled our car to the side and we were detained. What followed was a barrage of questions demanding I share my immigration status. Upon hearing how well I spoke English, one of the men with a gun clearly visible to his hip told me and my friend that he thought I'm most likely a citizen because he didn't pick up an accent, a foreign accent. I asked him if this is how he determined who was a citizen and who wasn't. And his answer was, it's a very good indicator. While trying to find my immigration status, they threatened me and that they would call the police to make sure that I had documentation that I just did not have on me at the time. After their investigation, they did let me go. Since this incident, there have been many other checkpoints in the state of New Hampshire, including right near where I live in Lebanon, where they boarded buses and asking people of color for proof of their citizenship. My friend, who was a Black citizen, was also flagged to be stopped and asked for citizenship in that checkpoint. Unlike me, other people were separated from their families, including a father and another brother to a citizen that had been here for many years, doing nothing wrong and working incredibly hard and contributing to our community. If you cannot find it in your hearts to sympathize with families, with children who are no longer able to see their family members, then I urge you to consider another impact. How this is hurting our state of New Hampshire, because many people have decided they will no longer visit the state because of these random checkpoints that cause severe traffic congestion. It's just the best interest of our state and our communities to alert the local media when these very problematic and very discriminatory immigration checkpoints happen.
Esma,
I'm done now, thank you.
thank you.
Are there any questions by the committee?
I do have a small question.
Representative Pratt.
I just have one question. Did you feel threatened by the police asking you your race?
You're talking about Border Patrol? Yes.
Thank you.
Representative Burt.
Thank you, Mr. Chairman. Thank you for your testimony. I too support this bill, and I have seen a lot of white people be involved in this too. So it's not just one side. That's why I support this bill. But the question I have is, what did this happen in Laconia area where they've been checking, putting these checkpoint Charlies up, as I call them, or was it down in the Lebanon area?
Yeah, the two incidences that I just described, the first one happened on a highway in New Hampshire. I forgot what highway that it was. It's in the article that I sent you. But the second one happened in Lebanon. So they happen in different locations.
Thank you.
Yes.
Representative Newman, do you have your hand up?
Thank you, Mr. Chair. Can you hear me?
Yeah.
And I'm not sure whether my video is on. I can't find the button.
It is.
Okay, thank you. And am I correct in my understanding that states that are further away than 75 miles from a border don't have this problem?
Yeah, if you're asking me, I believe it has to be 100 miles from the border, and the other checkpoint is in Woodstock, by the way. Sorry, the first checkpoint, but they have to be 100 miles from a border, and this was many, many miles away, but still within the 100 mile. But basically, most of the United States has a border that's within the 100-mile radius. So again, that means many people can get caught up in these checkpoints. The majority of New Hampshire, basically.
Thank you.
Further questions from the committee? Is that a hand?
Green. David.
Scott?
Here.
Representative Wallace, huh? Representative Green?
Thank you, Mr. Chair. My question is, have you been to any other state or country that's had checkpoints?
Yes, I have. I am from Libya, and we have checkpoints as well. And I don't consider Libya a free country. So if we're trying to compare ourselves with what some people may call third world countries, yeah.
Thank you.
Are there any other committee members who have a question? John?
Yep, we're good. And thank you for your testimony.
Thank you for having me.
Gillis is up next. Yep, there he is.
Thank you. How are you? Can I be seen or heard? I just wanted to make sure.
You can be heard.
Okay. Should I try to figure out how the camera works, or should I just soldier on, Mr. Chairman?
You have 2 minutes to testify. So.
Okay, well, I suppose I'll start. Well, Mr. Chairman, thank you so much for the opportunity to testify today. My name is Gilles Bissonnette. I'm the legal director for the ACLU of New Hampshire. And on behalf of that organization, I'm here in support of HB 579. I did submit last night for the committee's consideration some written testimony. And I just also wanted to flag that attached to my written testimony, just so the committee had it in its file. I attached first the provisions of the Attorney General's 2020 manual that governs sobriety checkpoints, just so you can see how those work in the state of New Hampshire. And number two, I also attached a notice in the form of an email that was provided by Border Patrol to the New Hampshire State Police. That was in advance of a Border Patrol checkpoint that occurred during Father's Day weekend. So I just wanted to send that to you so you can kind of see what those types of communications just look like in real time between federal agencies and the state police. And lastly, I also included in my written testimony a proposed amendment. So I obviously support using the notice that exists for sobriety checkpoints as a model for the notice that we think should exist for federal immigration checkpoints. But because there aren't clear-cut rules in New Hampshire as to how advanced in term of days that notice should be, I proposed an amendment in my written testimony that I think is kind of a simple fix to this, and frankly makes the bill easier to comply with and implement for state agencies once they become aware of a checkpoint. So this bill and why we support it, it's about checkpoints and the concerns we have with them, though immigration obviously is the context in which this has arisen and the context that this bill deals with. And the problem with checkpoints, in our view, more broadly, is that the government stopping individuals without any indication that a crime has been committed. That's the same concern with sobriety checkpoints, for that matter. Now, we obviously, as a state, can't tell the government, the federal government, what to do, but what we can do is require notice by state agencies to the public once they become aware of that.
Jill, yeah, you went past your time limit.
Oh gosh, I'm so sorry. Well, I'm happy to take any questions as well. My apologies.
Are there any questions by the committee? Representative Sessom.
Thank you, Mr. Chairman. Thank you for taking my question. I had the same issue with sobriety checkpoints, not thinking that anybody who gets caught in one had even noticed that there was one going to be held. I guess everybody seems to be so upset about a notification. What kind of impact is publishing a notice going to have on a immigration checkpoint? I mean, are people going to drive around it? I'm just trying to hear the use of it.
Yeah, thank you for that question, and I think it's a good one. And I think why notice is important is for the same reason it's become important in the context of sobriety checkpoints. It's just something that mitigates the intrusion. And for folks who are aware of it through notice, it gives them an opportunity to avoid that intrusion, which in this case is obviously coming in the form of a suspicionless stop. And so I really think it's important really for the same ways that it's become important in the context of sobriety checkpoints. It's just a mitigating factor, because the norm under the Fourth Amendment is, you're not allowed to engage in suspicionless stops. We permit them here in this limited instance, but to, I think, mitigate that intrusion, notice is important.
Yes, thank you, Mr. Chairman, and thank you for your testimony. Do you know how many stops they do a year in New Hampshire? And will this bill address the fish and game issue, that they have a fish and game officer come so they can do a search warrant of a car without a warrant, or a search of a car without a warrant?
That's a great question. And so the first answer to your question concerns the frequency with which these have occurred. There have been, I'm aware of at least 10 of these temporary checkpoints that have occurred in the past 4 or 5 years. There's also 1 or 2 that I know occurred during the 2012 timeframe. So, there's been an uptick of these recently. It would not address that fish and game issue. Really, this bill is just about notice. One of the issues that you're dealing with, we've litigated at the ACLU separately, which has to do with, can federal immigration agents use these stops to essentially engage in drug enforcement and then hand those individuals over to state authorities for prosecution for state crimes. And in one case that we litigated, a state court judge ruled that actually violated the New Hampshire Constitution, because the use of dogs was impermissible, because to use dogs, you actually need reasonable suspicion. And obviously none of that is occurring here. Dogs are being run along these cars without any indication of criminal activity. So the problem that you're raising, Representative Byrd, is actually kind of being addressed, or was addressed, I would argue, in separate litigation.
Thank you.
Representative True.
Thank you, Mr. Chair, and thank you for taking my question. Do you know what the process is when a federal agency is planning on conducting a checkpoint in New Hampshire? Do they contact the state police, the local police, the county police? Who gets contacted, or do they have to contact anybody?
It's a great question. I mean, they probably don't have to contact anyone, but they do, because they're engaging in these stops on freeways. Obviously, the state troopers, monitor freeways on the part of the state. And so what we've noticed through some public records requests is that when these checkpoints are set up, it is a very routine practice for the federal agencies to notify the state police in advance. And in recognition of that practice, we think it's only fair then at that point for the state agency that gets that notice then to just tell the public that it's occurring. So that is why I wanted to attach to my testimony as Exhibit 2 what that notice looks like. That's a document we received in response to a public records request.
Thank you.
Representative Newman, you're recognized for a question.
Thank you, Mr. Chair, and thank you for taking my question. Could you just give a brief comparison of how DWI sites are run and how these immigration sites might be run? For instance, I think in DWI they do like every 10th car or something like that. Are they similar or are they different?
Yeah, I'm not sure how it's done with respect to the number of cars that are stopped, but I can tell you when you look at Exhibit 1, which is the AG's manual on sobriety checkpoints, you have to submit a plan as to how you're going to conduct the checkpoint and probably address that very issue, Representative Newman, that you flagged, the frequency with which you're going to stop automobiles. You need to let the Attorney General's office know. And you also need to get, I believe, court approval in advance. And part of that plan to conduct the checkpoint includes a plan for advance notice, which is why I think there's some appeal here of having some advance notice with respect to immigration checkpoints. I mean, it is a somewhat different context here, but I think that's the idea behind trying to create similar notice here than that exists in sobriety checkpoints.
Representative Knight.
Thank you, Chairman, and thank you for taking my question. When you do the DWI checkpoints, do you ask for any demographic information?
Great question. I actually don't know the specific questions that are asked. I could look at the AG memo and maybe that would provide guidance, but you're not going to get asked, for example, like your citizenship. I don't think that's not germane, I would think, to the sobriety analysis, whereas that is a question, obviously, that's asked as part of these immigration checkpoints.
Seeing no hand raised, I want to thank the witness for his testimony.
Thank you very much, members of the committee.
Yeah.
Representative Perez, just a reminder that your testimony is limited to 2 minutes. It's Sebastian.
No, whoops, did I click on the wrong one? No, both of them are down there. I apologize, Mr. Chairman.
That's okay. Can you hear me now?
Yes.
Representative Perez.
Okay, thank you. Thank you for the opportunity to speak. As an immigrant and a person of color, I support this bill because it is hard for people, no matter where you're from, no matter, yes, it happens to people with a lighter color, but it happens more for people like me. And it's difficult to explain how it is to everywhere you go. If you think you're gonna get close to 100 miles, and sometimes it's difficult to remind yourself exactly where in New Hampshire 100 miles are, and then carrying your U.S. citizenship everywhere where you go. Because I wasn't born here. Yes, I am a U.S. citizen now, but it's difficult to be carrying your U.S. citizenship everywhere you go. And if you lose that citizenship, you have to pay to get a new one. And sometimes you have to wait a year to 3 years to get a new one. So that's one of the reasons that I'm supporting this bill, because we need to make sure that people realize, yes, it is important to have these checkpoints, but at the same time, it is important for people not be discriminated because they're colored or because of the accent or anything like that, and then don't feel like scared to go and visit these beautiful places in New Hampshire and be scared that you're going to be stopping in one of these checkpoints and you don't have your citizenship and you can go to jail. And sometimes it takes days or maybe a couple of weeks before you can get out of jail, even though you are a U.S. citizen. And thank you. That was my testimony.
Thank you, Representative, for your testimony. And the chair just will have a question. So, I'll just preface this by saying my father immigrated to this country and became an American citizen. And I don't recall him ever in his entire life, he's since passed away, but he ever carried any paperwork with him showing that he was a United States citizen. So is that the concern that you have, that you don't, there's no reason for you to carry? I wouldn't see one. Is that the concern you have with these checkpoints?
Well, the problem with the checkpoints now is like before it didn't used to be this way, that people be so scared about being put in jail because you don't have your passport or your U.S. citizenship. But now it is difficult because a lot of police department they feel like they have the immigration right, and then if you don't have legal right, they can send you to the immigration department. And sometimes if you don't have any of these documentations to prove that you are a U.S. citizen, even though you can be put in jail, and then you have to pay a lawyer until all these clears and they figure it out. You do it that in reality you are a U.S. citizen.
Thank you for taking my question, and thank you for your testimony.
You're welcome.
Seeing no members with their hand raised, I want to thank the representative for her testimony. Chair will now recognize Sebastian Fuentes.
Can you guys hear me well?
Yes, we can hear you.
Okay, thank you, Mr. Chairman and members of the committee. My name is Sebastian Fuentes. I'm just a member of the community, and I'm here to express my support for this bill. I'm one of the few immigrants. We went viral with this video that was recorded with our interaction with CBP in Woodstock, New Hampshire. I moved to New Hampshire because of the liberties that it promoted. Because for me, it's a really secluded area, but more even so, a beautiful state, especially when you head up north to the White Mountains, which is where I live and work. It's a great place to raise my family, and it's free of those dangers of the big city. I live in Thornton, which is the next town right after Woodstock on 993, which is where all these checkpoints happen most of the time. I experienced firsthand the treatment and professional contact from Customs and Border Patrol. They detained me 3 times already with no valid reason when I'm headed to work. My children are often scared for my safety because they don't know what's going to happen, even though I'm here, I'm a U.S. citizen. I also work in the hospitality industry, and I do understand the discomfort for many travelers coming to the White Mountains. In many instances, I have friends calling me or family members calling me ahead of time to find out if these Border Patrol checkpoints are going to happen in the highway. Mind you, not because they have any issue with their status. They're all U.S. citizens. They just don't want to deal. They just don't want the families and children to experience the level of harassment from law enforcement, especially in our state. They just don't want to deal with it. I do understand that CBP is following directions. I do get the fact that all our borders need to be secure. But the fact that there's a lot of residents in New Hampshire do not know that CBP has this 100-mile authority from any borderline. That's all of New Hampshire. That's about 80% of Vermont. They can come and go literally with no repercussion. They can harass innocent drivers. There's no excuse. They only ask for your citizenship. Often they judge the drivers by their accent. If you're a foreigner, you have to suspect you're going to be detained for at least an hour. They can assume that we're risky citizens because of our skin color, and sometimes, like my friend Asma, because you're wearing a hijab. I also, on my last time that I got detained, I suffered from asthma.
Mr. Fuentes, we do have to limit testimony to 2 minutes per witness, and the time limit has expired. The chair does have a question of the witness, if you don't mind. And let me just unmute you before. You did mention that there was a video that you recorded that went viral. Would you be able to forward a copy of that video to the committee?
Yes, sir. Yes, sir, absolutely. And I think the ACLU has it as well. I'll be able to provide that to you, yeah.
If you go on the New Hampshire General Court website to our committee, there is an email for the entire committee. If not, I would ask if the ACLU, if you're listening, to please forward the video as well.
Absolutely, I'll do so.
Representative Newman, you have a question?
Yes, I do. Mr. Chairman, thank you. Based on your experience, you said you've been stopped 3 times in one of these checkpoints. Is it your opinion that you were randomly stopped, or that there was some other reason they might have stopped you?
It can be a combination of everything. You know, they pull me over to the side. They're waiting for me to check my status, to check who I am. I think they check my license plate to see, you know, my car registration, to see who I am, and then after that they let me go. But yeah, that's pretty much what they do. I don't know if it's the skin color. I don't know if it's my accent, which is pretty clear. You know, I don't know, sir. I think it's something that needs to stop. And also, you know, like I said, I think it was asked to a SEIU member about when this happened. It happened during holidays in New Hampshire. It happened during Memorial Day weekend, Labor Day weekend, 4th of July. And also now the new trend is to happen during bike week in Laconia. They know there's a lot of bikers coming in and out, and they're going to stop randomly people and stop them for, you know, for carrying drugs with them, which I think that's not CBP's duty.
Thank you.
Representative Burkett.
Yes, thank you for your testimony, and thank you, Mr. Chairman, for having me, let me ask this question. So you said you've been through these checkpoint Charlies 3 times. Did they tell you to pull, you know, because I've seen many videos of these. Did they tell you to go to like secondary or whatever they call that? Or did you just stay in line and they questioned you and then let you go?
Thank you for your question. Well, when you go, I live, like I said, I live right next to the checkpoint, literally off the highway. I can see everything from there. So that's my way to go to work. So when I drive there, when that happens, they usually, you know, you can tell they let people go, and then randomly vehicles get stopped and they ask you what your citizenship is. If you say, you know, yes, they let you go. If you say no, you go to a secondary inspection. And sometimes that's the case, and sometimes that's not the case. So I don't know what criteria they use to judge. You know, I'm not a border patrol agent. I don't know how they're being trained, but in some instances, I think that there's an abuse of power there, or there's they don't know who you are, or sometimes, like I say, racial profiling might be coming into play. I'm not sure about that.
All right, thank you.
Thank you, Mr. Fuentes, for your testimony.
Thank you.
Seeing no hands raised, the witness is excused. Chair will now recognize Dr. Hannon, Dr. Joe Hannon.
Hello, members of the committee. My name is Joe Hannon. I'm speaking on behalf of myself. I'd like to just start with saying I appreciate the chair's comments about his father being a legal U.S. citizen and for years didn't have to carry his papers. But I'd like to mention the fact that I am married to a permanent legal resident. My wife has been here for many, many years and still does not have U.S. citizenship, but she has a permanent resident status. And she is required by law to carry her green card at all times under Section 264E of the Immigration and Nationality Act. And failure to have that on oneself at any time can result in a $100 fine and be put in jail for up to 30 days. It's unlikely to happen, but it can happen and often does happen. And it's nice to have a heads up sometimes. She does carry her card at all times, but you know, if you know there's a checkpoint, you're going to double check to make sure you have it on you because you don't want to be detained and have to be hassled. She's a practicing emergency room physician in this state. She has absolutely no accent whatsoever because she watched the Brady Bunch and listened to soap operas hours a day for years in the early 80s to make sure she didn't have an accent. She actually has less of an accent than me. And I don't want to make the mistake of saying a boot or and being confused as a Canadian either. So I think having notice of these checkpoints is very appropriate and absolutely necessary to prevent a lot of confusion. Thank you.
Representative Hopper?
No, thanks. No.
Thank you, Dr. Hannon, for your testimony. I'll just thank you in advance for taking my question. If you can clarify, you mentioned that if someone had a green card, that they were required to carry that by law. But if someone who's immigrated to this country has become a United States citizen, are you aware, are they required to carry any paperwork or documentation with them?
No, once you're a citizen, you don't need to carry anything. You know, I remember I was actually traveling internationally once with my soon-to-be mother-in-law and my now wife, and my mother-in-law just got her U.S. citizenship. She was heavy accent from the Middle East, and she was, you know, I'm an American citizen, and my wife is no accent whatsoever. She had to produce her green card, all the other papers, and well, side story, I was the one that got searched. But anyway, the point is, you don't have to carry it. But if you are a legal resident alien like my wife and many other people in this country who are allowed to be here permanently, they have to carry this at all times, accent or not.
Thank you for your testimony, Dr. Hannon.
Thank you very much.
Seeing no hands raised.
Shukran.
Mr. Chairman, I see nobody else.
Seeing no members of the public with their, have all the members of the public who wish to testify that are in attendance already testified? If not, please raise your hand. Seeing no hands raised, the chair will close the public hearing on House Bill 579.
Question,
Representative
Mr. Chair. Last year, I remember a bill to eliminate DUI checkpoints. Did that ever get implemented? I think we accepted, but did it get through the mess of last summer?
I am not sure of the answer to that question.
I can answer that if you don't mind.
Representative Burt, you're free to respond to that.
Thank you. I was interviewed by NBC News because it did get out of the House, so I thought that was pretty cool, but it died in the Senate.
Okay.
How was the interview?
It was cool. Yeah, no, they kept, you know, they wanted to know where they wanted to interview me. I said, well, we can go in the house, we can go out front of the house or out by my chickens. And then she kept talking about my chickens. Then she goes, do you really? She's out of Boston. She says, do you really have chickens? I said, doesn't every Massachusetts representative have chickens? And she laughed and she went back and they went back and filmed my chickens because they were like, oh my God, a representative with chickens. I didn't know we weren't supposed to have them.
We had a speaker one time that couldn't show up to a session because his milking machine broke down and he had to milk the cows by hand.
Yeah. God bless New Hampshire.
That was Doug Scanlon.
Well, the last bill for the day, House Bill 338, it's not noticed until 3:30, so the committee will be in recess until 3:30.
Good.
Representative Sullivan, the chair recognizes you to speak on your bill.
Thank you, Mr. Chairman. Thank you, committee, for having me. I'm here to present House Bill 338. It deals with dog theft and tampering with dog collars and microchips. This bill is identical to the amended version of House Bill 1117 from 2020. That bill was heard first in the Environment and Agriculture Committee. They're the ones that amended it. It was later execed by the Criminal Justice Committee and successfully moved on to the Senate, where it died a COVID death. What this does is it increases the penalty for stealing or poisoning a dog to a felony, a Class B felony. RSA 466:42 was last amended in 1977. This was before GPS collars or microchips existed. Tampering with the dog's electronic collar or the unauthorized removal of a microchip would be a misdemeanor under this bill. This bill brings RSA 466:42 into the 21st century and will help protect people's pets and working dogs. This is a bill that I brought on behalf of a constituent, Diane Richardson of Springfield. She is the true expert on this, and with all due respect, I recommend that she be called next. And with that, I will take questions.
Representative Burke.
Thank you, Mr. Chairman, and thank you, Representative, for your testimony. I am a huge dog lover, so the bill has caught my interest. The issue I'm having is the Class B felony. Can you explain how that became about, and do other states have the same as it's a Class B felony, or is it a lower punishment for what the bill is, the intent of the bill?
Thank you for the question. I'm not really aware of how this is handled in other states. Ms. Richardson might have a better idea. But I will say that just the collars alone are in some instances worth $1,000 and up. A well-trained tracking animal could be worth thousands of dollars. And I'm not sure if you're suggesting that it ought to be a Class A felony in some instances, but values of over $1,000 would qualify as Class A. The problem we ran into last year was determining the value of a dog. My mutt from Arkansas, I'm sorry, to me is worth over $1 million. But others might not share that value. And placing a value on a dog might be a difficult thing. So
Representative Sullivan, did we lose you?
Oh. Hope not.
Yeah. Well, thank you for your answer.
Can you hear me now?
We can hear you. Seeing no additional hands raised. Oh, excuse me, Representative Testament.
Thank you very much for letting me ask this question. Most people here are talking about, you seem to be talking about the dogs used for hunting game and so on. I can tell you from personal experience that spending $3,000 on a dog is not that hard. So, do you have any idea what the price is of various purebreds?
I'm a rescue dog kind of person, but I understand that they can get quite expensive. And I also understand that people with just household pets are using these tracking collars to make sure that if the dog escapes the yard, they can track the dog down. So this is not exclusive to working dogs, but I agree that purebred animals can be very expensive and a real target for theft.
Representative Marston.
Thank you, Mr. Chairman, and thank you for taking our questions. My question is in the realm of how easy or hard is it for the police to catch the perpetrator?
Well, I know in one instance that Ms. Richardson has heard of, someone actually tracked their collar to someone's home and knocked on the door and said, "I believe you have my dog." And they said, "Oh, no, that's not true." And they said, "I know my collar's inside your house." And with that, the spouse let that dog out the back door, and the dog came running around the house to the owner. So I can't tell you how easy it is for police to deal with this, but there certainly are instances where people get caught.
Thank you.
Seeing no hands raised, I want to thank the representative for his testimony.
Thank you.
The chair now recognizes Representative Comtois.
Thank you, Mr. Chair, and thank you, members of the committee. This bill, this is Representative Comtois from Belknap 7, representing Barnstead. I'm also a member of the Environmental and Agriculture Committee, which did a deep dive into this bill last term. And this bill was revised from its original form to get to the form that it's in today. And what we have to understand is, I'm hearing a lot of testimony about the price of a purebred dog, et cetera. But what people don't realize is with these working dogs and these hunting dogs, is it's not the value, actual dollar value of the dog, it's the time that's put into the training, which is invaluable. You cannot place a dollar value on that time and training, because a good hunting or tracking dog isn't worth what you paid for. It's worth a lot more than that. And as Ms. Richardson will testify, when these collars, people can remove the collars, so it'd be very hard to track the dogs, but people think that they're doing the right thing because these dogs are being harmed by doing their job. And what we're trying to do is put something on the books that will say to people, you know what? These dogs are healthy dogs. They're doing their job. They love doing their job. And because dogs love to serve their owners and love to do what they're meant to do. We have all different breeds. Some of them are house breeds and some of them are for tracking. Some of them are for working. And we have to allow the animal to do what it's meant to do. And some people just don't understand that, and they think they want to save the dogs, and they're doing them a disservice. So they remove these collars. There's been instances where they've removed a microchip, which is very painful for the dog. And we need to put in harsher penalty. We decided that a harsher penalty needed to be put in place to deter these acts. And I'm available for any questions.
Representative True.
Thank you, Mr. Chair, and thank you very much for taking my question. You and some other people have talked about, the value of the dog, but this applies to any dog, correct? Has nothing to do with the value of the dog or how much time in training you did with the dog, correct?
Correct. I can attest to, I can tell you from personal experience that I had a rescue dog that someone actually stole. The dog cost me $400. and he was a working dog, and someone just didn't like the fact that he was a working dog, and I couldn't find him for 3 weeks, and finally I located him. And they actually ruined that dog. I had to sell them the dog because the dog was no longer valuable as a working dog. And that's just one experience from me. So it's not just on the value of dogs, but this does happen, and I've experienced it personally. I don't know if that answers your question, but I hope it has.
Thank you.
Representative Hopper.
Thank you, Mr. Chair. Thank you, for Representative, for taking my question. The testimony is, if I understand it, that we need a Class B felony to make sure the punishment is strong enough to deter dog theft. My question is, how many people have actually served time for stealing dogs that you know of? In other words, if somebody steals a dog and they end up going to jail for 9 months, they probably won't do it again, but I don't know that it's actually being prosecuted.
Thank you, Representative, for the question. I cannot answer that at this time because I haven't really delved into it. Ms. Richardson is really the expert on this bill and has done a lot of research, not only in this state, but in other states. And she could probably answer all of those questions better than I can.
Thank you.
Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. I'm just curious, is why this bill is only to dogs? Because I have several friends that have pets that are not dogs that they have paid a lot of money for and or got for free and love them just as much, and they're just as valuable to that person. So is there a reason this is only to dogs and not all pets?
Thank you, Representative, for the question. There isn't a reason. It just seems that this is a movement across the United States specifically to dogs. Dog theft is real, and it is happening in all 50 states. So I can't say why we haven't addressed other pets in there, but so I can't really answer that question, to tell you the truth. So.
Representative Wallace.
Thank you, Mr. Chairman. And thanks for taking my question, Representative. Seeing that the theft of dogs is growing and it's a real problem nationwide, would it also not make sense maybe to have some penalties on whoever might be trading or receiving these stolen or kidnapped dogs?
Thank you for the question. Yes, we did not want to make the bill too complicated to start out with because we narrowed it down because there's a lot of other things involved in this because we have to deal with law enforcement, animal control, et cetera. So we didn't want to do too broad of a bill and wanted to really focus on this. But if that's something that you think should be in there, I'm not opposed to that.
Representative Knight.
Thank you, Chairman. Thanks for taking my question. What is the total number currently on the theft of dogs in New Hampshire?
Thank you for the question. I don't have that number. So I can't answer that question.
Knight, you have a follow-up question?
Yes, thank you. And your dog when you found your dog, was there anything physically wrong with your dog?
No, my dog was perfectly healthy, except that he was a working dog, and you cannot confine a working dog and stop it from doing its job and then think it's okay for them to come back. Dogs are trained, or dogs are bred for certain purposes. And when you try and change that and you pull them out of their environment, it's very hard to, for them to get back into that. So.
Representative Bournet.
Thank you, Mr. Chairman. Thank you for taking my question. Now, if You, in the state of New Hampshire, if a theft is worth over $1,500, that is classified as a Class A felony. If it's between $1,000 and $1,500, it's a Class B felony. Anything less than that is a misdemeanor. So if you have a dog that is worth, let's call it $2,000, including its collar, that could be prosecuted by present law as a Class A felony, and you would make it a Class B felony. Is that not true?
Thank you for the question. Before this, it was classified as a misdemeanor, and we pushed it up to a Class B felony. And because some people had a problem with the Class A felony, and because people are saying, well, how do you put a price on a dog? What is a dog worth? I would, and I'm not a lawyer or a judge or anything, but I would assume that you would be able to go for further damages. I mean, these collars alone are upwards of $1,500 to $2,000, as you will hear testimony. I mean, dogs have been killed because owners couldn't have them tracked. They've been run over. I mean, there are horrific stories out there. And, but when we heard this in the Environmental and Agricultural Committee, the Class B felony seemed to be what we thought was the right thing to do at the time. So.
Seeing no further questions, I want to thank the representative for her testimony.
Thank you, Mr. Chair.
Diane Richardson.
Can you hear me?
Yes, we can hear.
Okay. Hi. My name is Diane Richardson. I'm a lifetime resident of New Hampshire, and I've been involved with purebred dogs since 1985. We have personal dogs that work in the woods and fields, including a shed antler dog, human tracking dog, and 2 dogs that are licensed with Fish and Game to track wounded game. I've submitted a pretty detailed written testimony for you, and I urge you to read it. It's got a lot of information in it from other parts of the state as well. This bill was created at my behest by the sponsors to address a growing problem. The problem is nationwide and not restricted to New Hampshire nor to hunting dogs. It's a problem in all the states for all the dogs, be they working or pet dogs. And it's, as you heard, it's pet theft and collar tampering. Current law does not specifically address tracking collars, tracking devices, or identification microchips, only collars. This absence, unfortunately, has caused law enforcement to be hesitant to press charges for tracking collar tampering or removal, and there is zero New Hampshire law addressing microchip removal at all. My dogs wear a GPS collar while they work, and many hunting and working dogs also wear them. Additionally, many pet dogs now wear a type of GPS collar or GPS tag, and a large portion of dogs are now microchipped. Unfortunately, there's a population segment that are catching dogs, removing collars, shutting tracking collars off, and even destroying tracking collars, and taking the dogs to either save them from their misconception that the dogs are abused or to flip the dogs for profit. Aside from the dog's value, collars can run $100 up to thousands of dollars, depending on the type of collar you have. Many states do have tracking collar laws. In some states, they're felonies, and in other states, they're misdemeanors. It varies by state. Microchips are a form of positive identification, and tracking collars are a way for owners to track.
Ms. Richardson, we do have to limit testimony to 2 minutes. And seeing no hands raised, I want to thank Ms. Richardson for her testimony. Oh, excuse me, Representative Hopper.
Thank you, Mr. Chair. A quick question. I'm having a little difficulty with the penalty. So what I'm trying to find out is how many people are arrested for stealing dogs now, and how many of them have been given jail time of 9 months, 6 months? In other words, are we increasing a penalty to deter something when we're not even we're not even enforcing the law now?
Currently, when someone is arrested for stealing a dog, typically because current law is that it's a misdemeanor, it is usually a release on personal bond, and they come back and they get a slap on the wrist. And it's not much of a deterrent.
Thank you.
Seeing no hands raised, I want to thank the witness for testimony. Stacy Ober.
Good afternoon, Mr. Chairman, members of the committee. Thank you for this opportunity to speak on behalf of the American Kennel Club in support of House Bill 338. And I just want to acknowledge that the AKC is a nonprofit that's recognized as a trusted expert in canine health, breeding, and training. And we represent over 5,000 clubs nationally, including 22 in New Hampshire, which represent thousands of dog owners. And in New Hampshire, for instance, in 2019, there were 141 dog performance events hosted with more than 23,000 dogs participating. So it's a very popular sport in New Hampshire. And just want to acknowledge that the current New Hampshire law regarding theft of a dog has not been updated since 1977. I did look at the annotated laws, so it being a misdemeanor has been in place for a very long time and has not been updated to reflect the current value of some of these dogs that are working dogs and purpose-bred dogs, purebreds that are worth quite a bit of money, as Rep. Comtois noted, especially given that they may be highly trained. And that also the electronic technology for tracking the dogs can be quite expensive and likely was not available back in 1977. I just wanted to acknowledge that in my written testimony that I shared with all of you, there is a link to an AKC article from 2018 noting that dog theft has been on the rise for several years now. And on average, the studies estimate that about 2 million dogs are stolen each year in the United States. I can share with you that it's an unfortunate problem because there are those who recognize the value of these dogs and they're looking for a way to make quick cash or to breed the dogs for money. So it's not specific to just hunting dogs or working dogs.
Ms. Ober, we do have to limit testimony to 2 minutes per witness. Representative Tessman, you have a question for the witness?
I have a question. This is not only for working dogs, pets and so on. Does this also apply to dogs that are purpose-bred, or not purpose-bred, but used for service dogs, like, you know, for a veteran and so on, like General Bulldog has one that costs $30,000, I understand.
Yes, I can share with you. I had a contact a couple of months ago from a woman in Maine who relies on a service dog. The dog was stolen so that it could be bred. She's been unable to get the dog back despite a court order in Maine. I also had probably 6 weeks ago, a police officer in Worcester, Massachusetts contact me noting that dog theft has been an issue in that jurisdiction. There was a question earlier, and I just wanted to offer that there are 2 states that apparently impose different charges and penalties based on the monetary value of the stolen dog. So it may be that an owner could, in fact, produce some evidence of, you know, the value of the GPS collar or of the dog themselves, the hours of training that's been put in to assist a court with the appropriate charge, depending on the value of the dog.
Representative Newman.
Thank you, Mr. Chair, and thank you for taking my question. it sounds like what I'm hearing about the penalties, and that's mainly what I'm concerned about, is that a Class A felony was not considered because a lot of times they plead down or whatever. But it seems like whether it's a Class A felony or A or B or C, Class A or B felony or a Class A misdemeanor, that could happen with any of them because the minimum penalty can be held down. And I'm just wondering if you would be open to any reconsideration of the Class A misdemeanor. Thank you.
This is Stacy Ober responding. If I may, Mr. Chair, I just wanted to reflect this bill, which is a refile and came out favorably from House Environment and Agriculture. I did monitor the House Committee on Finance last year, which considered this bill, and they raised, which is why I raised it in my testimony, whether or not a Class B felony was significant after understanding the value of some of these dogs, but also acknowledged that they were not the committee with subject matter jurisdiction to increase the felony to a Class A. And I think part of that is a reflection of Class A felonies, if you look in the statute, is theft of property over $1,000, and a Class B felony in New Hampshire is theft of property over 500, but less than 1,000. If you look at the general statutory language. So I just would ask the committee to perhaps review that in making your determination.
Thank you. Representative Gaffrey.
You mentioned that, I guess dog theft is on the rise in the United States. Do you know or have you heard of the people that are stealing the dogs? Are they repeat offenders?
I'm sorry, I don't have access to that information. I think if I were to speculate, I would say yes, because it sounds as though there is kind of a black market for those individuals who see this as an easy way to flip dogs and to generate some quick cash.
Oh,
Representative Gaffrey, you recognized for a follow-up question?
yes. Well, I guess for me, I'm struggling with the fact that you want to make it a felony. So have you considered maybe first offense, misdemeanor, second offense, maybe something else, a stronger misdemeanor, or second offense, a felony, versus a first offense?
Representative, this is Stacy Ober with AKC. I'm appreciative of Rep. Sullivan filing the bill. It's his bill. And Diane Richardson, his constituent, I would defer to them and your expertise as the Criminal Justice Committee.
Thank you.
Seeing no further hands raised, I want to thank the witness for her testimony. The chair now recognizes Joseph Mullen.
Good afternoon, Mr. Chairman and honorable members of the committee. My name is Joe Mullen. I'm from Grafton, Massachusetts, and I'm the Northeastern States Assistant Manager for the Congressional Sportsmen's Foundation, the 501c3 nonprofit I represent today. I would like to express my support for House Bill 338. I know that this legislation applies to all dogs across the board, but I will be speaking to the significance of this legislation to sportsmen and women and their hunting dogs. I will also be submitting written testimony to the committee capturing my points. Across the nation, the crucial roles that dogs have in the hunting community consists of tracking game, pointing and flushing upland birds, and retrieving downed waterfowl. Sportsmen and women have a strong affinity to and connection with their hunting partners and often dedicate significant time and money into the training and upkeep of their dog skills. In New Hampshire, dogs are a regular part of the hunting culture and play a vital role to volunteer leash dog trackers and as sportsmen afield and on the water. Hunting dogs serve as an extension of the sportsmen and women working in tandem and as a team. The removal of a dog's collar or complete theft of a dog is a serious outward attack on a hunter's ability to enjoy our nation's time-honored traditions. Speaking from a personal sense, I utilized my retriever's electronic collar for both training purposes and for command recognition in the field. I've spent more money than I'm willing to admit on his preparation going into each season. But more importantly, he's a valued member of my family. Expanding the protections for dogs and setting high thresholds of liability presents a clear recognition of the contributions that dogs have in the sporting community. Once again, I'd like to reiterate my support for House Bill 338, and I thank you for your time.
Seeing no hands raised, I want to thank the witness for his testimony. Witness is excused. Are there any members of the public who wish to testify that have not already? Seeing no hands raised, at this time we'll close the public hearing on House Bill 338. And at this time, we do have about 15 minutes before we have to close out. So we could conduct the executive session right now on House Bill 338.
Here we do have some people who signed in. We had 25 people sign in support of House Bill 338, and we had 5 sign in against it.
Thank you, Representative Muse. Representative Hopper.
Thank you, Mr.
Are
Chairman.
you asking a question?
I was going to make a point before we started voting on it.
Are you making a point of order?
No, just a point.
We are on a limited time, but
I realize that. I just want to say that I will support this if it concludes the Garthright amendment, which makes the second offense a felony, but not the first. I don't think this comes even close to the penalty equaling the crime.
well, there's going to be a motion, and we'll open up for discussion. At this time, the chair is opening up the executive session on House Bill 338. The chair recognizes Representative Welch to make a motion.
I move House Bill 338 be ought to pass.
Is there a second of that motion?
I'll second it.
That motion has been seconded by Representative Green. Representative Welch, you wish to speak to your motion?
Well, I kind of, what Linda has suggested is something that I've always felt as though the position we should take. But on these dogs, the working dogs, they are extremely expensive. There's a lot of time and effort goes in there. And I'm in a position now where I have a dog, which I bought earlier last year. It's very expensive. If anybody wanted to steal my dog, I'd shoot him. No question about it. But, I would. 12 gauge, double barrel.
Isn't that part of your family?
It is part of my family. At my age, that's what happens. The kids leave and you get a pet.
Representative Marsden.
Thank you, Mr. Chairman. On this motion, I have a problem. And I hope I can express it well here. I am inclined to be ought to pass, but I find that in some cases, a D felony is not enough. How do can we amend this thing so that in a case where this dog is say, and I got a note here, somebody said, a purebred show dog or a purebred dog can be $2,500. My point is, can we make this a graduated type thing, a certain point for a B felony and an A felony? Is that something that could be amended?
So that's certainly something that can be done. I think this is based on the testimony, the difficulty is establishing the value of dogs is sometimes difficult to do, especially in a court. All right. Listen, I don't have a problem. I had a purebred dog. It cost $3,000. If you stole $3,000 in cash from me, it would be a Class A felony. What I understand is that this is a fight to make this a Class B felony in the first place, so I'm willing to take the baby steps to get there. I would support making it a Class A felony, because I think stealing a dog is inherently wrong, and it is how it's, listen, stealing anything is wrong. Stealing my water bottle is wrong, stealing my briefcase is wrong, stealing my computer is wrong. Stealing someone's house pet, I find to be more disturbing, just given the known emotional attachment people have to that property. I wouldn't really lose much sleep over the loss of, you know, the stuff I have with me here, but when it comes to a house pet, I find that to be very unfortunate. And I would say if this was any other type of property, I don't know why house pets, especially a dog in this case, is basically getting less consideration as property. Because that's what a dog is. It's your property rights. And that dog, if I understand sometimes you can get them from rescue shelters, so you didn't spend that much money on the dog. But for us to start distinguishing between, oh, did you buy it? It's not what you paid for, it's what it's worth to you. That's how baseball cards are done, comic books are. And to me, making this a Class B felony, I would find to be very appropriate. I would support it making it a Class A, but I would try passing it as a Class B first.
I hadn't quite finished my statement. Okay.
I apologize,
That's
Representative
okay.
Martin, I was out of order.
Mr. Chairman, a point of order.
Representative Newman, your point of order has been raised.
I'd like to raise a point of order. Yes, sir.
You've been recognized.
I thought that I heard the chairman say that we were going to 4 o'clock. I'm just wondering if that's still in effect.
Well, I did say that I've been given the green light to go a little longer. There is going to be some maintenance done that would require the internet to be disconnected. So, are you asking me, is this a problem if we continue this?
Another point of order, if I may, I guess I'm recognized.
Order was.
Are we going to go through our normal procedure of one question per person? And this is a regular executive session, and it will go on like one until you reach the point where we have to stop. Is that right?
The question you're asking is not a point of order. You're not asking about a ruling of the chair or the parliamentary procedure. You're asking a general question. So your point of order is out of order. Representative Marston.
Thank you, Mr. Chairman. What I was saying was the value of a dog can be determined by many different factors. I have a daughter-in-law that's in the dog raising and breeding and selling. They know the values of different breeds and different dogs, and many other factors come into play. So I'm just saying, I would like to see an amendment that grades the penalty if you catch the criminal. One of my questions, if you recall, had to do with, are we catching these people? Because it's a moot point if we don't catch them. Thank you.
Representative Bourdonnais.
Thank you, Mr. Chair. I think the bill is okay, except that I think that the penalty is wrong, based on value alone. And I think that a simple amendment would be to strike the felony Class B felony to just make it a felony, and then let the value of the theft say whether it is a Class A or B. That's what I have to say.
Representative Burt.
Thank you, Mr. Chairman. I think Representative Bourdonnais and I are going to agree on something today. You know, to start off with a Class B felony, I'm just having a big problem with it because I look at Chicago laws, how well they work. So I'm sure this being a Class B felony will just send everybody that's going to steal dogs, you know, oh, I guess I got to get a job at the gas station. You know, I just look at it, Mr. Chairman, as it's a feel-good bill. I mean, am I for punishing people that steal dogs? I would be devastated if my dog came up missing. You know, Annie is worth $1 million to me. But, you know, it isn't going to, you know, Class B is not going to stop the criminals, just like out in Chicago. You know, you look at the crime rate and, you know, like Representative Bourdonnais said, you know, let the value, we have current laws. He makes sense on that. We have current laws that dictate what it's going to be, you know, with the value. So if it's more than $2,500, I guess it is a Class B or, so, you know, I'm going to be voting no on this. Thank you.
Representative Knight.
Thank you, Chairman. Thanks, colleagues. I just want to say I'm inclined to agree with this bill, but also think that it needs an amendment. And I don't understand why we're limiting it only to dogs, as well as Representative Rhodes stated. It just seems like it should be more broadly to pets. It's like kind of, I don't know, it's kind of biased. And then what other concern I have is consistent lack of data on all of our issues that are being brought forward. We need to know how many people are already in trouble for this, how many are second offenders. Right now, we're just taking the words of everybody saying this is a problem, and we have, you know, nothing solid. So I'm having major problems making a decision based off of the lack of data.
Representative True.
Thank you, Mr. Chair. Yeah, once again, Representative Klein Knight, agree. We agree often. I can appreciate the fact that we want to get these bills to the House, to the floor, and I've got so many questions. One of the questions is, why is it just dogs? Are the penalties too harsh? I have to think long and hard about that. Is it needed? Is this bill needed? I don't know how many dogs are stolen in New Hampshire. Is it enforceable? Evidently, it's not being enforced now. Maybe if we increase the penalties, maybe prosecutors would be more apt to enforce it, but way too many questions for me to support the bill. Way too many. Thank you.
Representative Newman.
Thank you, Mr. Chairman. And I think that hell might freeze over today. I agree with John Burt and Representative Marston, and I am also opposed to the Class B felony. Thank you.
Isn't this a conundrum?
Well, my understanding, I'm just listening to the members speak. Some people are opposed to it being a Class B felony, and some members want it to be a sliding scale, and then some members want it to include more than just dogs. So although there's some opposition to the motion as written, I don't think the opposition are all on the same page. That's just what I get. And I will just say that I am the representative that has tried to go read House Bill 174. So you see where I try to make house pets on the same playing field or equal level. So I agree with Representative Knight's statement. My concern with doing that is I don't want this bill to fail on its merits because we want to add a cat or whatever. So I would say, but let that be argued on its own merit. You don't want to see, if you add too much to it, I think you can make it complicated. But that's just my opinion. I recognize Representative Welch who was speaking again.
Well, I was just going to say that for anybody who thinks a Class B felony is too high, if you're charged with a Class B felony, it doesn't necessarily mean you're going to get, that's the way it's going to go. Think about it. There's all kinds of methods that people, that law enforcement takes to make a deal. So Class B is not, in my estimation, not too high. Class A, I could go with that.
Representative Testament.
somebody, and I forget who, I think it was Representative Bordnay, said, is there a way to make it just a felony and then, you decide what the pet or working dog was worth?
Yeah, we can amend it, take the class B out and leave it just
A felony. I mean, that sounded to me to be an excellent solution, because I'm not sure Class B is strong enough. And I don't like making it a misdemeanor, because the police aren't going to mess with that. You got to make a felony to get their attention. So they'll have to make a decision on what level of felony it is. So I'd like to see somebody withdraw this, and we'll put a amendment in and then come back to it.
If that were the case, would you be the one that actually goes to get the, what's in for the?
I would, yes.
Representative Hopper.
Thank you, Mr. Chair. Again, hell freezing over isn't necessarily a bad thing. The problem is, we don't, again, what was said, we don't have enough information. Like, in other words, an 18-year-old kid steals a dog because he's drunk. Now he's convicted of a felony. He can't get a freaking job. He can't own a gun for the rest of his life. He can't defend himself for the rest of his life because he was drunk one night. Versus what the real issue is, which is people who are repeat offenders who are stealing dogs for profit. So we're not separating out the people that are really the target of this legislation from the people who might just do something stupid once. So I can't support it unless we have more information as to why aren't people being prosecuted now that it's a misdemeanor? If nobody's being prosecuted, why does all of a sudden making it a felony mean that they are prosecuted? There seems like there's something wrong with the system, because somebody who steals a dog that they spent 6 months in Valley Street for, they're probably not going to do it again. Because it's not like they're doing drugs and they're compelled to do it again. It's something they're doing for to make a few bucks. I don't know. I'm for ITL unless it's amended.
I guess the question is, if I may ask, what would you wish to amend the charge to, a misdemeanor?
I would think the first one would be a misdemeanor, and the second offense would start being a felony, because the first time they're prosecuted for the dog, they're going to say, look, if you get caught again, you're going to lose a lot. It gets real serious after this. So it gives somebody some, anyway. Plus, you're probably going to get shot by Representative Welch anyway.
Representative Byrd.
Thank you, Mr. Chairman. Representative Klein Knight mentioned several things that refreshed my memory that I wanted to bring up, and she's exactly right. We heard some testimony from experts, and when they were asked for data, oh, well, yeah, we'll circle back around and get you because we don't have the data. That kind of threw me for a loop too, and I forgot until Representative Knight mentioned that. If you come to a hearing, you should bring the data that's probably going to be asked. And if this is a national problem, I would think there'd be plenty of data, and nobody had any. So, again, that's another reason. But, and if we're going to do the amendment, I support what Gary's Representative Hopper said. And why don't we add all animals? Why do we have to discriminate against a cute cat or, a ferret or any other animal that could cost a lot of money? I don't know how much those things cost, but, why are we discriminating against other animals?
Representative O'Hearn.
Thank you, Mr. Chair. It's only a suggestion, but with all these questions, I would suggest that maybe if we can take back the motion and maybe have a subcommittee with all the reps that have some problems with this and come back with a good amendment. Would probably be in order.
I will tell you that a subcommittee is a tall order during these troubling times. So that's the issue. I'm listening to the people talk about the amendment. I'm willing to allow Representative Welch to withdraw his motion. But I guess my concern is it sounds like different people want different amendments. We only put one amendment forward. And those amendments that they want to put in, they can't coexist. Some people Representative Testament wants to make it a higher penalty, Representative Hopper wants to make it a lower penalty. So you're gonna have competing amendments. I feel like the middle ground of that is what we have before us, which we had this bill last year, and that's why it was a Class B felony, was the competing arguments. And that's in respect to both Representative Testament's argument and Representative Hopper's argument. The middle ground is making it Class B. And that's what was passed in this committee last year.
I don't think this was it last year.
Representative Testament.
Could you make an amendment that said, first offense, misdemeanor, subsequent offenses are felonies?
The amendment can say what it wants. I'm just telling you that a purebred dog costs $3,000.
Oh, I know.
And if you stole $2,000, you're gonna get a felony charge on what? So we're making exceptions for an animal for some reason, which is property. Any other property would not have an equal playing. I'm just surprised we want to make it such a light penalty. We're worried about teenagers drinking. I'm just surprised. I mean,
I'm worried about first offense, I think. That's what we're worried about. But a felony for first offense.
But if a first offense,
I love dogs.
But a first offense, if you stole $2,000, you're gonna get a felony. Why would a dog all of a sudden?
This is a dog. It's not a person. That's why.
Well, let's say you stole cash.
Even a cat. I mean, I agree with that. We're just talking about dogs, and there's so many other animals out there that people buy. I agree with that.
Wrap it up, so we don't have time for vote. So, Representative Welch, do you wish to withdraw your motion about the pass?
I will withdraw that motion.
Lovett, is there a second? Representative Green, you wish to second?
Yes.
Clerk, call the roll. Just housekeeping.
To withdraw?
Yes.
They had questions.
We did last time.
You did?
We voted on that. We did last time.
I don't believe it's necessary.
With the motion being withdrawn, we will adjourn.